Sarah Boone had a plan, a twisted little game. Jorge never saw it coming, but she knew just the same. In the darkness of the night, with a smile so sly, she whispered, "Let's play a game," and he didn't ask why. She zipped him up tight in the suitcase of love. No air, no light, just the stars above. He thought it was a joke, just a lover's embrace. Sarah, he cried in that tight, dark space. Jorge was laughing, but his breath was thin. The walls were closing in as the fear kicked in. He called out her name, but it echoed in vain, while Sarah watched coldly, not a hint of pain. She zipped him up tight in the suitcase of love. No air, no light, just the stars above. He thought it was a joke, just a lover's embrace. Sarah, he cried in that tight, dark space. Love's a game of risk, a dangerous thing. In the suitcase of love, it's a deadly flame. Sarah's smile fades as the silence grows. In the suitcase of love, nobody knows. Morning came with silence, no breath to be found. Sarah unzipped the case, Jorge's last sound. She stared at the scene. What had she done? In the suitcase of love, there's no place to run. She zipped him up tight in the suitcase of love. No air, no light, just the stars above. He thought it was a joke, just a lover's embrace. Sarah, he cried in that tight, dark space. Love's a game of risk, a dangerous thing. In the suitcase of love, it's a deadly fling. Sarah's smile fades as the silence grows. In the suitcase of love, nobody knows. Love's a game of risk, a dangerous thing. In the suitcase of love, it's a deadly fling. Sarah's smile fades as the silence grows. In the suitcase of love, nobody knows.
Well, good morning, good afternoon, good evening, good night, everybody. Whoever you are, wherever you are, whatever you're doing, whoever you're doing it with, however good it feels, however many times you're going to do it. I don't care. I'm just glad you're doing it here with me. And why is that? That's because we're all family here. The Vice Squad is the greatest chat on the entire internet, and we're glad to have you here. So welcome to Legal Vices, the channel where law meets life, and we dissect the cases that grip the world, from the high-profile cases that dominate the headlines to the hidden little gems that you've never heard of before. I'm here to break them down in ways that are engaging, enlightening, and occasionally a bit irreverent, and hopefully a little bit entertaining sometimes. Whether it's the headline-making courtroom drama, the shocking criminal trials, the legal battles, or whether it's just anything else that comes our way, we just break it down for you. The fact, the legal twists, the shocking developments, the jaw-dropping moments that you need to know about. Are you ready to dive into day whatever the heck this is of the Sarah Boone trial? This is, what are we in? We're in day 4 afternoon and day 5 morning. That's what we're doing. Day 4. Are you ready to dive into afternoon of day 4 and the morning of day 5 of the Sarah Boone murder trial? Crime, controversy, justice, it's all at stake here. It's going to be a wild ride, so buckle up, hit that subscribe button, hit that like button, because we are your front row seat to the law's most gripping stories, which today happens to be the Sarah Boone murder trial. All right. We really have got a lot of ground to cover today because They had a very long afternoon yesterday. We need to get into this as quickly as possible. Very, very, very quickly. I swear, I promise very, very quickly. We just need to do a very few housekeeping items. The first item of housekeeping that we need to do today is day 41 of the emotional support potato pig dogs. We have had a continuous 41 days of the emotional support potato pig dog cam. They are here. They are standing by to step in and give you the emotional support you need if they are unlocked. If their achievement is unlocked, they are here for you. It's entirely up to you. It's all up to you. We don't do the grifty stuff. We don't do the begging stuff. We just have a reward for you at the $100 mark, whether it's Super Chats, Venmo, PayPal, Cash App, gifted memberships, purchase memberships, whatever. When we get to that hunty mark, we unleash the emotional support potato pig dogs. Will today be day 42? That's entirely up to you. All right. With that out of the way, we have our like and subscribe poll set up. Our like and subscribe poll today is very brief, very short, and very to the point. We've heard from the prosecution. We've heard from almost all of the defense. They've got a couple more witnesses left. We've heard from the defendant herself. So if right now, they said, okay, the trial's over. If everybody just shuts it down right now and says, we're done, how would you vote? What would not what you think the jury is going to do. What would your personal vote be? She's guilty of second-degree murder, or she's not guilty because of the battered spouse defense. 7% of you say not guilty because of battered spouse. All right. Well, we're off to a good start. We'll check back in an hour or so. And look at the top of the chat in both YouTube and Rumble, and you will see a link to get your bingo card. We do bingo here. We do trial bingo. This is the Boone's Big Bingo Bonanza. I can't even remember what I called it, but that's what it is. Click generate and play along with us. It helps you focus on the trial. It helps us pay a little more attention. It helps us look for things. We're sort of be more aware of what's going on in the courtroom. And it's fun, I guess. You get bingo, say bingo and chat, and we all go yay. And then we move on to see if you get second bingos, like the hobbits in their second breakfast. Do you get second bingos and thirds? And we just have fun with it whilst paying attention and learning. Let's see, we've got the bingo, we've got the doggo cam. I'm forgetting something. Oh, yes, the official Sarah Boone trial cocktail is the Boone Tang Suitcase. Vodka and Tang. That's it. That's all basic. And we also have the forbidden snack tray. She wanted her juice box. She can't have her juice box, so we got our Capri Sun because, hey, we're not on trial for murder. And she specifically requested Pop-Tarts, which they turned down. We have frosted strawberry Pop-Tarts today. So we have our Sarah Boone Tang Suitcase cocktail. We've got the forbidden snacks. We've got the doggo cam up there, just waiting to be unleashed. We've got the bingo card. I think we're ready to go. I think we're good. Just hit the like, hit the subscribe button, and we are very, very close to 81,500 subscribers right now. We are at 81,400 and it's buffering 50. We're at exactly 81,450. 50 more subscribers. 50 more subscribers, and we get to 81,500. And we got 333 concurrent viewers, 156 likes. Do it. Let's go with the afternoon of day 4 of the Sarah Boone murder trial. Bring that up. We're going to be watching it at 1.25 speed, skipping through everything we can. If the witness speaks a little slowly, we will bump it up to 1.5. And let's go. Right, I'm in place. They're in place. And I think I'll move up a bit. There we go. All right, ladies and germs, let's go.
Mr. Owens, you may call your next witness, sir.
Your Honor, the defense calls Ms. Pearl Walker.
Pearl Walker. Who is Pearl Walker? Day 4 afternoon, kicking off right now. Oh, wow. We will fast forward this because it may take Miss Pearl a little while to get up there. she's the grandma from Deadpool. Sweet. She's a grandma from Deadpool. You get her, grandma. You get her, Meemaw.
Can you raise your right hand, please? Please do swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you.
Ma'am, good afternoon. Could you state and spell your name for the record for us?
What did you say?
Can you state and spell your name for the record
Pearl
for us?
Walker. Pearl Walker, Walker.
Thank you very much, ma'am. Mr. Beck, you may proceed.
Good afternoon, Ms. Walker. Ms. Walker, do you know the defendant, Sarah Boone?
Yes.
How do you know her, ma'am? How do you know Ms. Boone? If you can't hear me, just ask me to repeat myself.
Okay.
Y'all got to talk louder. Meemaw is not in the prime of her life. Come on, everybody. Talk a little bit louder, not only for Meemaw up there, but for us watching here. We all need you lawyers to speak just a little bit louder.
How do you know Ms. Boone?
She lived in the same apartment building that I lived in.
And can you tell us how long the two of you shared the same apartment complex, apartment buildings?
About 4 years.
And how is it that you became familiar with Ms. Boone?
My husband and I was sitting out on the porch, and we see her coming with her 2 dogs.
And what happened then?
Then I would call her over with her dogs.
And what do you mean by call her over?
When I see her walking with a dog, and I see her, and I look at her, and I said, "Hey, Sarah, how you doing?" And that's it.
She's
And
Italian.
would she
Sarah, how
generally
you
respond
doing?
to you?
Yes.
And how, look, I won't go there. Would you spend time with Ms. Boone?
Did I spend time?
Would you spend time speaking with Ms. Boone?
Yes.
How long would you speak with her?
About 15 or 20 minutes. That's all.
And was your husband sometimes involved in those conversations as well?
He just say hi.
So you and Ms. Boone were the two primary communicators?
Yes, sir.
Okay. In the time that you knew Ms. Boone, did you witness anything about her person or her body that gave you cause for concern?
Sometimes I would see it like she had been choked around her neck or her arm be hurt. I have a mark on her arm. And I just asked her.
And would she describe how that happened?
She just say, I had a,
Hang on.
Understand.
Objection is sustained.
Yep. Prior bad acts, bad character evidence. Can't bring it in.
When you would ask her that, how did she appear to you to respond
Hearsay.
emotionally to your questions about her injuries?
she just say, one of them days or something.
Objection sustained.
Can't say what she said.
Just
Hearsay.
for the record, instead of telling us what she would say, would she demonstrate any emotion on her face?
Well, I would see the emotion that she was upset about something.
We've never seen a minute
And
of emotion on her. Well, we saw
Did
her
you
smile
ask
once.
about her obvious upset persona, her upset,
Appearance. Face.
the fact that she was upset? Would you ask her about that?
Yeah, well,
Okay, you have to just limit your answer to the question. Would you ask her about that issue? About why she was upset?
yeah.
Okay, and I'm sorry, I just can't go beyond that. Thank you. Now, how frequently would that occur?
I would say on the weekends when I see her.
No, every
Was
weekend.
that primarily when you saw her on the weekends?
mostly I would see her walking through, going to her place, and I'm sitting on the porch and I see her then.
Now, strike that. While you were there in that apartment complex, and excuse me for getting ahead of myself, do you still live in that apartment complex?
No,
How long have you been gone from that apartment complex? If you don't know, that's fine.
oh, it's been a while.
Thank you, ma'am. During the occasions that you
All right, I'm going to say this now. Shame on the defense for putting this woman on the stand. Shame on them. This is literally the only person you could find in the entire neighborhood that Sarah spoke to in the last 4 years. Shame on you. Shame on you, defense. Shame, shame, shame.
had
Mimon
to
did nothing to deserve this.
interact with Ms. Boone, how did she treat you?
Objection.
She was a nice lady,
Overruled.
nice to me.
Did she ever act uppity?
Oh, dude. Dude. You did not just say, was she acting uppity to a black woman, did you? Sweet baby dumpster Jesus. I have just about seen it all now.
Overruled.
Did she ever treat you in an uppity manner?
Yep, he did.
What you mean, sir?
Did she ever look down on you as a person?
Oh, no,
Did she ever treat you with disrespect?
no.
I'm going to object. This is character. Sustained.
Exactly.
May I approach on this, Your Honor?
Yes.
It's character evidence. It has nothing to do with this. That cannot be allowed. Legal Vices Hail Marys by the defense doesn't happen in football. It doesn't happen in the courtroom either. Yep. This lawyer is a douchebag. He is a grade A government certified inspected douche cannon. This part of the trial brought to you by Diet Coke, the beverage of choice of second-degree murder defendants. Jeez. Oh my God, I can't believe. Yeah, Law Talk with Mike said he was sleazy. Yeah, exactly. He's a sleazy lawyer. What a douche cannon. Yeah, which lawyer is this that's doing this? It's the other one. it's the other guy. Oh my gosh. Yeah, they had to search the entire neighborhood to find a single person to testify in her favor. And it turned out to be an elderly lady in a wheelchair that couldn't hear. Oh my God. She was nice to the homeless puppies. Well, yeah, because she had 2 handicapped dogs. One was deaf. I think Penny was blind, and I can't remember what the name of the other one was. Deaf. The fact that I know the names of Sarah, at least one of Sarah Boone's dogs, is kind of concerning to me. All right. Oh, we can skip through this. I forgot this is not live. Skipping through. This is a long sidebar. Wow. Lawyer calls for sidebar. Mark off lawyer calls for sidebar on your bingo card.
I'm sorry, I'm back, Mrs. Walker.
This is your
In the time
This
that
is
you-
the douche cannon right here. It's the other guy that we've only seen like twice. So all hail the douche canoe.
You and Ms. Boone lived together. On occasion, did you see law enforcement arrive at the apartment complex?
A couple of times.
And did you ever get involved in any of their investigation?
Wait, were the law enforcement there to arrest her for abusing him or him for abusing her? How the hell does she know why the cops are there? Oh,
No.
Were you ever approached by law enforcement and asked for information, evidence, insight into what might be going on?
No, sir.
Now, in all candor, were there occasions when you believed that Sarah Boone may have been under the influence of alcohol?
No.
Oh, Sarah's never been
can't
drunk.
say.
Did you also observe George Torres during the time that you lived there in the apartment complex?
I didn't see him very much. If we sitting on the porch, that's the only time I see him.
Did you know Mr. Torres very well?
No.
Incoming raid from Aussie Overlord. Welcome, Aussie Overlord Raiders. Make sure you hit that like button as you come in and subscribe if you haven't already done so. We are on day 41 of the Emotional Support Potato Pig Dogs. Day 42 is all the way away.
Was there an incident when you saw Ms. Boone with a black eye?
Yes.
Yeah, she remembers that's what she's supposed to say. Murzulandia, this witness seems to be no use for the defense. I agree. She's just saying, oh, I saw her with all these marks all over her.
Did you witness a pattern between Ms. Boone and Mr. Torres wherein you observed signs of abuse?
Objection, foundation. Sustained.
You testified that you saw Ms. Boone on occasion with bruises, other injuries, and a black eye. Is that correct? Is that accurate?
Yes.
And was there any pattern to what you observed in regards to those injuries and bruises that you observed on Ms. Boone?
One time I seen with a black eye and like she had been choked one time.
Okay.
Okay, went from every week to twice. All right, thanks, Mima.
Did Ms. Boone complain to you about those marks?
Yes.
Thank you, Your Honor. Nothing further.
Any cross-examination?
Hi, Ms. Walker.
Oh,
Is it fair to say you're not sure when exactly you saw any of those injuries on her, correct?
say that again?
You're not exactly sure when you saw any of those injuries on her, correct?
Once she come past the apartment, I'll be sitting out there because we always sit out there.
Yeah, 4
Right,
years
but
ago
we don't
or
know
today.
if this is December or 2018 or anything
I
like that.
can't remember, sir.
Okay. And is
I
it,
like. Oh hell no, I can't remember anything. Yeah, thank you. That was a good. That was good for the prosecution.
fair to say you have no idea how she got those marks? Is that fair?
Repeat that again?
Do you have any idea how she got those marks?
On the weekends, I see him and her go in.
Okay. But you don't know who, if anybody, put those marks on her, right?
Well, I
Just
can-
calls for yes
I
or
can
no.
tell when they must have had an argument or something. I hear the dogs barking.
Okay. And you're 5 doors down, right? Unit 8, Unit 3?
Yeah.
No other questions?
Any redirect examination?
No, Your Honor. Thank you.
Can this witness be released?
Yes, sir.
Thank you very much, ma'am.
Oh my lord, that was useless. And shame on you,
Ms. Walker, the
defense lawyer.
deputies are going to come get you and take you out, okay?
We all done?
Yes, ma'am. Thank you so much.
That poor woman. That poor woman. Jason JJ, member for 14 months. Thank you so much, Jason JJJ. Thank you so much for the support over an incredibly long period of time. And Mursulandia, this witness seems to be of no use for the defense. She was of no use to anybody, and it's not her fault. And Annie Simmons. Good morning, folks. That's really loud. Good morning, folks. Not shitting on anyone else's channel, but I was mystified seeing people say they're torn between whether she's guilty or not. I can't get past those videos. Intentional or not, she is responsible. It's intentional. She has admitted it was intentional. See, this is the thing that people need to realize. And I'm not trying to sway anybody's views one way or the other, but By bringing in this battered spouse syndrome, she has effectively said, I intended to kill him. Whereas the entire time she was lying, she told the cops, I didn't intend to do it. It was an accident. We were having a good time. We were having fun. But what she wants us to believe now is they were fighting all day and she intended to kill him because if he got out of that suitcase, he would do that to her. By relying on the battered spouse defense, she has essentially said this is intentional. So the question is it, although it's intentional, is she excused by reason of battered spouse syndrome? And in order for that to happen, she has to prove the burden of proof is now on her to prove that she was a battered spouse and suffered from this syndrome. One of the things she has to prove, well, the three things she has to prove are that George is dead. We all agree to that. That she caused the death, which she said she did, and it was done out of an apprehension of immediate and imminent threat of grievous bodily harm or death. She had to believe that something happened in that immediate future that would justify her thinking she was in fear of bodily harm or death. And I don't think she's done that at all. What happened a month ago doesn't have anything to do with what happened that day. And she was the aggressor, I think. So people got to keep that in mind because they heard a lot of people I saw, even in my chat comments, a lot of people changed their mind. A lot of people were swayed more towards her side because they heard this horrible litany of abuse. You know, they saw the pictures of the stab wounds in the leg, the marks on the thighs, the marks on the neck, the black eye, they heard all these things. Well, the defense gets a chance to rebut that. They get a chance to put on evidence that she was the aggressor. They get to put on other evidence along those lines. Plus, again, all of those things doesn't necessarily mean something happened that day to put her in fear. And she can't say, oh, I was in fear that he was going to get out of that suitcase and whoop my ass when she was the one that zipped him up in here. She created the risk. She created the danger. She created this situation for him to retaliate from. So anyway, that's just my little horse my little soapbox that I'm now going to jump off of. D there says, what I didn't understand is why the prosecution didn't bring first degree murder when the self-defense came in. Well, she's already been charged one. And proving first degree murder in a case like this, all she's got to do is say, I didn't mean to do it. I didn't intend for this to happen. Then she's off. Because they can't really prove that she intended to kill him. But anyway, we have a couple more things here coming in. Seed Fan 85. So I don't know where it happened. I don't know when it happened, but I heard dogs barking from 5 apartments away. Right. Why was she called? She was called because she's a little old lady and, she was the only one they could find. And she would, seemed like she would pretty much say whatever, she needed to say. Amber with the blonde hair. That's the witness that Owen said yesterday that he wanted to release and Sarah wanted to keep. Oh, I don't get what she thought she'd get out of it. A friend she'd get out of it. That's the one. All right. Well, we're there. We can fast forward now to the beginning of the next witness, who I believe takes up the rest of the day. So, all right. I guess it's a longer break than I thought. All right. Is this
Sick work while I work.
Oh, this would be Dr. Harper. All right. Let's get to the beginning of the Harper trial. Oh, she's a happy face. At least I'm guessing it's a Harper. All right, we are now 1/3 of the way to unleashing the emotional support potato pig dogs.
Again, members of the jury, if you could, just raise those hands, confirm you complied with the court's instructions. Record reflect all hands have been raised. All right, defense, at this time, you may call your next witness.
We call Dr. Julie Harper.
I guess I should spell afternoon correctly too.
Please swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Doctor, good afternoon. Could you state and spell your name for the record for us?
Dr. Julie Harper, Harper.
Thank you. Counselor, you may inquire.
Thank you, Judge. Good afternoon.
Good afternoon.
I think you've already stated your name, but just introduce yourself to the jury.
My name is Dr. Julie Harper, and I'm a licensed psychologist.
All right, Dr. Julie Harper, licensed psychologist, will be the, I have to finish typing the word psychologist here, psychologist, save and run our banner. And then, wait, why isn't it saving? There we go. Running our banner and then introducing one of our co-hosts for the day. Ozzy Overlord is here, everybody.
Wood.
Okay.
How you doing, folks? Good to see you. All right, so this is the defense psychologist expert. So this is the one that spent, what, the 3 days with her, or?
She looks like one of the little villagers in the dark crystal that the Skeksis suck the life out of for their energy.
Oh my god, everything leads back to the dark crystal with you, doesn't it?
Pretty much. Pretty much. Okay.
To be fair, I do look, I can see people in chat saying, you know, whatever, but all I'm going to say is he stopped at a very unflattering angle, let's be honest.
Or Dr. Bunsen Honeydew from the Muppets in Drag, one of the two. All right. Enough of that. That's shame on me. Welcome, Ozzy Overlord. We're glad to have you here. Thank you for joining us. It's late your time, but not extraordinarily late. We've got a long day ahead of us, so you're welcome to stay as long as you possibly can.
Sweet.
All right, let's get after this. Let's get on that thing. Hakta.
Would you tell the jury your educational background?
I have an undergraduate degree from Oberlin College in biopsychology. I have a master's degree from University of Denver. I went on from my master's degree to earn a psychological doctorate. That's called a PsyD. That was also from University of Denver. In completing that education, I specialized in psychological assessment, which means I had extra coursework in that area.
I choose to change my vote. I can't stop looking at her nose now.
Test other people. I completed an APA-approved internship at Washington State University, which means that I was matched, and that was my site to practice being a psychologist for a full year, and that was between 1999 and 2000. And following that, I turned in my dissertation, which was in the passing of power in couples relationships. I then graduated and started my postdoc work in Pullman, Washington. As part of becoming a psychologist, you have to have over 1,500 to 2,000 hours of supervised work as a psychologist. The person that supervised me was a forensic psychologist. So during that postdoc time, that was my introduction to forensic work while I worked at a community mental health center.
Dr. Harper, how long have you been licensed?
I was first licensed in Washington State in 2002, so 22 years.
What type of position have you held as a psychologist?
Well, I was rehired at my internship site, so I worked at Washington State University College Counseling Center. I also worked 2 times at a community mental health center. The first time was in Pullman, Washington, and that was during the period of time where I was getting my postdoc hours completed, and then I stayed on after licensure. I also worked in Florida. When I came to Florida in 2005, I took a position in the Fort Walton Beach area at Bridgeway Center, which is a community mental health center. And while working there, I completed a variety of psychological assessments. I was directing the testing program. I also began working during the Department of Juvenile Justice contract work for evaluating adolescents that had gotten into legal trouble and needed an assessment for consideration of program placement. I worked in that community mental health setting doing clinical assessments and the DJJ contract and Social Security evaluations, and continued that until about 2010. In 2010, I opened my own private practice, which is Northwest Florida Psychological Services. And in the beginning of the practice, it was a combined clinical and forensic practice, meaning that I spent a majority of time doing psychological assessments to answer questions from physicians about things like ADHD, depression, to make treatment recommendations. I had therapy patients, and I also did, again, Social Security disability evaluations, so numerous kinds of assessments. And then over time, I began doing more and more forensic work, including receiving appointments from judges to do competency to stand trial evaluations, sanity at the time of the offense evaluations for Circuit 1 in Florida. And I continued to do the Department of Juvenile Justice contract briefly, but then that it came up for bid and I discontinued that contract. What I did is I slowly reduced my clinical practice, because when you do forensic psychology, it means you have to travel. Your individuals that you're seeing are not usually out in the community. A lot of times you have to see them in jail. So it's hard to maintain a therapy practice, and I scaled that back over time. Eventually, my practice became entirely forensic. And then in 2017, I took a job with the state of Georgia to be an evaluator full-time. I was working doing competency to stand trial and sanity at the time, the offense evaluations, and then assisting with risk assessments in the inpatient setting. I did that until 2021. At that time, my private practice was just quieted down, of course, from COVID, and I was not in full-time practice, so I wished to return to full-time practice with my own company, and I did that in May of 2021. And since then, obviously, the courts are busy again. We're all recovering from the COVID era and back to full-time practice.
Now, where do you live?
I live in Okaloosa County, and that is in the panhandle of Florida.
And is that where your practice is currently?
Yes.
Is it fair to say you travel the state to? Is it fair to say you travel the state to do assessments or evaluations?
That's correct. I travel to a lot of cities throughout Florida, far south as like Miami, and then of course working along other
Is
cities.
it fair to say that you testify in various counties throughout the state?
Yes.
And I know that yesterday you were set to testify in Bay County, Panama City.
That's correct. I was testifying yesterday in a death penalty case in Bay County.
All right. And when you finished, you drove here?
Yes, I did.
I understand.
Ladies and germs, we have a huge announcement here. Chaos Coordinator dropping the heat with 10 Legal Vices memberships. If you are IT Goatee, if you are Caldrak, Emily's Dismantling Delulus, Ray, Cindy Miles, Eric Wolfrick, Detective Wabuffet, Captain Useless TV, Morgan Lawless, and Yoga Cat. You are the 10 people that got the gifted memberships. Make sure you give Chaos Coordinator a super, super special thank you. And that puts us 3/4 of the way to unleashing the emotional support potato pig dogs for day number 42 in a row.
Damn.
And you got here after midnight.
Yes.
What other counties have you testified in?
Well, I've testified here in Orange County, in Miami-Dade, in Duval. It might be hard for me to list everywhere. Alachua, Escambia, Santa Rosa County, Walton County,
All
Bay
the
County,
counties.
Washington.
So just so the jury understands, the nature of practice is you have to travel throughout the state.
Well, I do work in cases where the person is at risk of succumbing to the death penalty. And so those cases require repeated evaluations in different vicinities. And so I have been, traveling to work on murder cases. There are psychologists, I suppose, that do forensic work that might just confine their work to one circuit or stay, but I actually broadly travel.
She's a traveling broad. You heard it here first. All right, ladies and gentlemen, we have another thing here just to announce very quickly. Born Sinner has just gifted 5 Legal Vices memberships. Goddess of Hard Solder. That's an interesting name. Goddess of Hard Solder. TJ, Nikki Lynn, Bev Murray, and Toadette were gifted the memberships. Thank you so much, Born Sinner and you 5. Make sure you give Born Sinner a super special thanks. This weekend, we will probably be doing our members only stream. So stay tuned for that. And Jinver with a 5. We got the 5 here from Born Sinner and Jinver. Where are you at? I'm confused. That's nothing new. Too much excitement. There's Born Sinner. Thank you so very, very much. Jinver. Hypothetical. If George got out while she had the bat and killed Sarah, could he have claimed self-defense? Yes, he can claim self-defense. Whether a jury would buy it or not, we just don't know. But he could sure as hell claim it. All right. We have reached that part of the show right out of the gate, very early on in the show, which is always awesome. That part of the show where we give the command to release the hose. And we introduce our third and possibly fourth co-hosts. It's Strawberry. Strawberry's here, and Yoda's over there, as always. So Strawberry's moving. So we'll put Strawberry there for day 42 of the emotional support potato pig dogs. We don't need this anymore. Day 41 is history. We are now in day 42 of the emotional support potato pig dog cam streak. Thank you so very much. Now we're going to get back into this, and we're going to be interrupting a lot less so we don't get more behind than we already are. Thank you, everybody.
Your practice is now entirely forensic?
That's correct.
What you said? And you've testified about what kind of forensic work you do?
Yes. So as a forensic psychologist, sometimes I am tasked with testifying about something very specific. So for instance, a person's ability to stand trial if they're knowledgeable and can go forward with their trial process. I've testified about a person's sanity at the time of the offense, meaning if they had a mental health condition that met the statute as to not being sane at the time of the offense. I've testified in sentencing hearings. I've been an expert witness for Department of Children and Families. I've testified in vocational rehabilitation hearings as their expert in what's called social investigation. That's what they used to call custody evaluations. So in numerous capacities.
And would it be fair to say that a lot of times you're appointed by the court to provide the service that you provide and you're paid by the state?
That's correct.
What percentage of your work is where you're paid by the government to do the work?
I would say that the majority of my work comes through with that court-appointed funding. Percentage-wise, probably about 90%.
Okay. I realize you testify on occasion by the state, but majority of your time, 90%, 95% of the time, you testify on the behalf of the defense?
Yes, the evaluation's complete, and either side can call me for testimony, and the majority of the time I'm called by defense.
And so you make a living by traveling the state, and generally the court system, I think they call it JAC, pays your fees.
So I make a living by performing work as a forensic psychologist, evaluating individuals, most of the time that are incarcerated in a prison or a jail setting, providing consultation to attorneys who might just have questions that would need a psychological expert to explain something to them. I also do fitness for duty evaluations for law enforcement, pre-employment evaluations for law enforcement and firefighters. So depending on the work that's needed, I do those.
Doctor, how is a forensic psychological evaluation different than a regular psychological evaluation? Can you tell the jury?
Sure. So if any of us went into a psychologist's office and had an evaluation done, it would be most likely for treatment. So things like if you qualify for surgery or you can have treatment, maybe you've got a condition that you want therapy for. A psychological assessment is very helpful in identifying a diagnosis and then setting a course for treatment. A forensic psychological evaluation has many of the same procedures, but the aim is really different. The aim would be to answer some kind of legal question that is posed. So as an expert, I might be in the position to provide some education or experiential descriptions of something that a person might be suffering from.
Oh, by the way, mark off dog cam on
your. So for instance, if it's a competency evaluation, I would educate the fact finder. In that case, it would be a judge about what is wrong with the person, or if they had any deficits at all, or if they were competent to proceed. In a situation like this, a forensic psychological evaluation might be geared more to identifying, again, if there is a mental health condition present in the defendant I'm evaluating, and then to provide a jury with education about what I found in my evaluation.
How many forensic psychological evaluations have you conducted? Estimate.
So just as an estimate, it's clearly more than 4,000. I've been doing forensic psychological evaluations as far back as 2007.
Have you been qualified as an expert to testify in forensic psychologist in court as a forensic psychologist?
I have.
And you said you've testified for the prosecution
Yes.
and you've testified for the defense.
Yes.
Is there any difference in the work that you do depending on who hires you? Which side?
Absolutely not. A forensic psychological evaluation is an objective assessment of what's going on with the person. So you should be performing the same kinds of procedures and doing evaluation. It should
Objective.
not
She would
matter
never do
who's
anything
retained
to
you. What you're trying to do is answer a question.
favor the people that are paying her
Are there
bills.
times when you actually do an evaluation and assess an individual, but then you're not actually called to testify?
Yes, many times that's the case. You will provide your feedback to the attorney, and then it's up to the attorney to decide if there's anything in there that would be useful to them, or if they're pursuing a certain kind of information for the court, they would choose to call you for testimony.
Dr. Harper, do you recognize Sarah Boone at the defense table with Tony Henderson?
I do.
When did you first get involved with Ms. Boone?
The distortionist, I'm actually
It
loading
would
a
have
pipe
been
right now. We'll
in
talk about it
around
later.
June of 2020 was the first I heard of her case.
And what were you asked to do?
A comprehensive psychological evaluation of Ms. Boone.
And did you do that in Ms. Boone's case?
I did.
Okay. Were you given materials to review?
I was.
Is that standard operating procedure?
Yes.
You assess the client individually, one-on-one, and then there are collateral evidence or material that you also consider?
Yes.
Tell the jury about that.
Yes. So in forensic work, there are a variety of documents that are usually available in assessing a defendant. In this case, for criminal court, you would see things like witness statements. There might be body cam footage or just more information about the offense itself. Sometimes there's an interrogation video. So you would get kind of the legal description of the offense and the things that have occurred. I also will often get educational records of a person, mental health records, hospital records, things of that nature that would describe their biopsychosocial history to me.
And you were given materials as it relates to Sarah Boone to review?
Yes, I have that.
How many times did you meet with Sarah Boone?
So 9 times.
All right. Can you tell the jury what you did as part of your evaluation of Sarah Boone?
Well, we had clinical forensic interview in which I reviewed her background history, so her early childhood. I also assessed her with assessments, meaning I administered 3 psychological tests to her. I reviewed her prior mental health records, her interrogation video, some prior information about her legal history. So she had been previously arrested. I reviewed that as well. We had an opportunity to review the transcript of her interrogation video. So there were a variety of things that would be considered what I did with her.
Okay. So you considered some medical records?
Yes,
And did you also consider some records from George Torres's records?
I did see his hospital records.
Now, do you consider, in doing an assessment and forming any opinions, an individual like Ms. Boone's upbringing in terms of where they grew up and what their family environment was like?
Yes, that's part of gathering their background history, so biopsychosocial information.
And did you consider Ms. Boone's upbringing in forming any opinions?
I did.
Can you tell us a little bit about that?
Yes, so of her history, I found it pertinent that she was raised with.
Conduit 704.
All right. She wants to say something that the prosecution doesn't want her to say. Don't know.
Are we
what
really
it's
shocked by that, though?
Nope. Aussie Wombat member for 5 months says, why do so many psychologists sound so condescending? I don't know.
I think it's part of their training.
Yeah. And the distortionist says, what type of pipe do you use? Today it's Halloween. So today the pipe I'm using is my custom made, where is he? Let's see if we can get focused. Can we get focused on this? Oh, come on. Here we go. It's my custom made Cthulhu pipe. This was custom carved for me. So it's got some nice
The
stuff.
objection is sustained.
That's the pipe I'm smoking to.
Would you have considered, as part of her family background, whether or not some of her family members had passed away early in her life.
Objection, legal conduit 7-4.
Sustained.
You considered the entire family background and history without going into the details of what she said or what you learned from looking at records. I'm sorry?
Yes.
And did you
Cthulhu,
consider
not a
her
squid.
relationship with her mother as part of her psychological development?
Yes.
Now, do you believe that Sarah Boone does have some narcissistic traits?
I do.
She doesn't qualify or meet the criteria for that diagnosis, does she?
I did not diagnose her with that.
Can you elaborate on or explain how you feel that Sarah Boone does have some narcissistic traits?
Well, in meeting with her as part of the evaluation, the narcissistic traits that I identified would have to do with, as she described, being a straight A student. She reiterated about her abilities, and I felt that that was evidence that she had low self-esteem, and her coping mechanism was to
Oh, interesting.
identify what made her stand out.
She's an
And that
expert
would
at
be
everything she.
consistent with a narcissistic trait.
Now, I know there's been reference in this case to a manual that all psychologists, all psychiatrists refer to. Do you have that manual with you?
I do.
And what is the name of that manual?
It is the Diagnostic and Statistical Manual of Mental Disorders, the text revision. So it's the DSM-5 text revision.
Now, Dr. Brandon testified earlier today, and there was some evidence relating to when you suffer from narcissism, there's a sense of grandiosity. But is that
That you excel at
from this
everything?
manual and your studies and your experience, where they require excessive admiration and whatnot, that there's a reason for that?
If I'm understanding your question, there's a criterion in narcissistic personality disorder related to
What
that.
I'm getting to is many times you may have these narcissistic traits, but really you suffer from very low self-esteem.
That's the underpinning of that criterion.
Would you explain that to the viewers?
If I'm allowed to reference the DSM, then I can explain it best.
Just don't read from it. Just
All
you
right.
need to review. If you need to read a paragraph and then explain it to the jury.
Kudos
So
to
based on the description
Evolve
in
Recovery
DSM,
Emma, the newest member of the Clean and
if a
Sober
person's
crew.
self-esteem is very fragile and they have low self-esteem, they may require more outside admiration or even appear more grandiose in their abilities because at root, they don't feel secure and confident. And so it's what we would call a defense. And so that criterion is actually a way that a person tries to make themselves feel better.
Anything else you want to say about that issue?
Well, you asked me about why I didn't diagnose narcissistic personality disorder. And again, from the DSM,
Or the criteria?
there are criterion for each disorder.
And so when you're assessing someone, they have to meet all those criteria for you to form that opinion that they actually suffer from that disorder.
Well, the first, I guess, issue is, do they have the criterion that are listed? And then the second would be, is there a different mental health disorder that would better explain the criterion that you're seeing? The criterion within the DSM overlap considerably across disorders. And so there are some helpful guidelines within the DSM to remind you of that you may have what's called differential diagnosis. So if you're considering one thing, that you also are directed to look at other things. So that happened in this case, in this instance, that the DSM guided me to also look at other things.
But just for purposes, to make it clear, you did not diagnose her with narcissism, that disorder.
That's correct, because the DSM's description guided me that that would not be an appropriate diagnosis.
Why did you not diagnose Ms. Boone with a personality disorder?
Well, first of all, it has to be a pervasive pattern of distorted relational abilities. So basically, if she is demonstrating in a variety of settings that she has these symptoms. And then secondarily, the diagnosis of post-traumatic stress disorder is listed when you're considering personality disorders. The DSM guides you that if there are personality changes that are associated with the exposure to a trauma, then you should consider post-traumatic stress disorder and not a personality disorder.
Have you diagnosed her with anything? And we'll elaborate on that, but through your assessment, have you diagnosed her with anything?
Yes, so she has a diagnosis of post-traumatic stress disorder. She has symptoms of anxiety that would be consistent with post-traumatic stress disorder. So that is an anxiety disorder.
And you feel like she suffers from post-traumatic stress?
I do.
Now, at the time of this incident, this event, we're talking February 23rd of 2020, you were aware that she did not have much family support.
Yes.
Doctor, why do you administer psychological testing?
Psychological testing allows an objective measurement of what the person's symptoms may be as compared to sort of an average. So if we can see what the average range on a standardized measure would be for any person, if there is an interpretable difference, that gives me clinical information. So it's not just relying on what the person has told me. I've got an objective measurement that I can compare to other people. And then I also administer psychological testing in a forensic evaluation.
Wait just a second. We had a bit of a system malfunction here.
I was going to say, ruh-roh.
All right, we're back.
Have a reason to minimize symptoms, or they may exaggerate something else. And so assessments as to the person's response to you and if they're validly participating are important.
Be that day.
So there are tests to see if you're faking or malingering or that type of thing?
Right. And so you would call it feigning mental health symptoms when the person is either far exaggerating a symptom they do have, or if they're pretending to have a symptom that they do not actually have.
Okay. Now, as it relates to Sarah Boone, what type of psychological testing did you administer?
I administered the inventory of legal knowledge, and that is a test that has to do with whether or not she was validly participating regarding her understanding of the legal process. I also administered the Miller Forensic Assessment of Symptoms test.
Now, explain to the jury what that Miller Forensic Assessment of Symptoms test is.
So that is also a test of feigning to identify if she's validly participating in the evaluation. So if she had endorsed psychological symptoms or psychiatric symptoms that would be unusual or not typical of a valid psychiatric patient.
What were the results of Ms. Boone's test on the Miller Forensic?
She validly participated. There was no indication of any feigning or malingering.
As far as the inventory of legal knowledge case, what were the results?
Again, she was validly participating, and she did not even come close to the cutoff. That would put her in the range of feigning.
Can you tell the jury what the purpose of the clinician-administered post-traumatic stress disorder scale is?
Yes. So that would be considered a very useful assessment of post-traumatic stress disorder. It allows me to interview a person about exposure to a traumatic incident and then identify if there's a change in behavior that has occurred as a result of that exposure to trauma.
And just in fairness and full disclosure, my boomering did not cause that glitch, but in the process, I sort of did boomer the response to it. So if you want to get technical, go ahead and click off Vice's boomer something on your bingo card. Boomer! Let's get back.
At the time that you administered that test, did Ms. Boone in fact have post-traumatic stress disorder?
Well,
or tell me the results.
Yes. So the results would be consistent with a person having post-traumatic stress disorder. I do not diagnose from one test. That wouldn't be appropriate, but it is consistent with the background and the symptoms that I had previously, taken down during my evaluation of her. So the clinical portion, when we go through symptoms, that was consistent with the outcome of that test.
And with this testing, all the testing, help you determine if Ms. Boone had a change in functioning from before the alleged trauma to after the alleged trauma. And I'm referring to the trauma. We're going to talk about what the trauma was, but the trauma was the intimate partner violence?
That's correct.
Okay. But would that testing help to determine if she had a change in functioning from that trauma of the intimate partner violence?
Absolutely.
And did you determine that she did suffer from a trauma as a result of intimate partner violence?
That was my conclusion. Yes, that's my opinion.
Now, in considering all the available information, you don't just rely on what Ms. Boone tells you to make your decisions.
No, I don't. I do interview a person as part of the clinical forensic interview, of course, but I also consider things that are reported, like in their arrest narrative, witness statements, all of the medical records. So there are a variety of sources of information, collecting data points and reviewing those to arrive at a conclusion.
So you did review Ms. Boone's previous diagnoses in her history?
Yes,
Did you consider the previous diagnoses in arriving at your own?
I did. Yes.
What did Ms. Boone, what had she been diagnosed with prior to you getting involved?
Section 7400.
Approach.
All right. I didn't hear what that approaching was about.
He objected to her referencing previous diagnoses by other medical professionals.
Was
Which,
that
frankly,
what
I
the
think should have
objection
probably been part of her research anyway, but at least we're actually getting into the testimony itself, because the foundation stuff, honestly, was going to put me to sleep.
was? That took a long time.
Yep.
But you would agree, I think this is a fair question, you would consider prior other experts who may have diagnosed her with something.
So I would definitely consider her mental health records, diagnoses previous clinicians may have arrived at the time
Okay.
when I diagnosed her myself.
Okay, given the assessment that you did with Sarah Boone, and considering the totality and the time you spent with her and the other records, did you diagnose Sarah Boone with anything?
Yes, so post-traumatic stress disorder, it's my opinion at the time of the offense, she had depression and she had an alcohol use disorder.
All
So
right.
she was a depressive drunk
I know
with
we talked about
PTSD.
post-traumatic stress disorder. I don't know if I need to ask you anything further. I think the jury probably understands that. Is there anything else you wanted to add about that disorder?
I'm not sure what the jury's already been told about post-traumatic stress disorder, but in Sarah Boone's case specifically, because of enduring, she specifically noted the time that she was stabbed with a knife as being an extremely.
Sustained.
You have viewed have you viewed some exhibits involving her being stabbed?
I think that we have had exhibits in common. I'm not sure what was admitted.
Have you seen the physical scar from Sarah Boone being stabbed in the back of the leg?
Yes, I've seen her scar.
You're saying?
Overruled.
Just generally, without getting specific, I think I've explained post-traumatic stress, but if there's something else the jury you believe the jury needs to know, but it's a sort of trauma that occurs as a result of one or more events.
Post-traumatic stress disorder is the psychological after effect of being exposed to a very significant stressor or cumulative stressors that make the person's behavior, thinking, and mood change. And so
She had to correct herself
the
then.
change can include things like the person becomes
What was
hypervigilant,
that?
is easily startled, has trouble thinking, has trouble sleeping. So their body is in a state of agitation. It can also include changes in mood that would include irritability, difficulty relating to others, and that they might be resistant to trust easily. So those are all each.
They have trouble sleeping sometimes.
Yes,
Sleep deprivation is a real issue.
it's associated with things like nightmares and having trouble settling.
Now, you mentioned that you had diagnosed her with depression. Can you just give us a general understanding for the jury of depression?
So the persistent sad mood, including feelings of hopelessness, helplessness, having difficulty concentrating, sleep problems, changes in appetite, those would be typical of depression.
And Sarah Boone suffered from that?
Near the time of the offense, yes.
Or can you explain to the jury alcohol use disorder? That's a fairly new name. That's 5 or 6 years ago. The manual came up with a different name.
It did, right. And so that would be, in layman's terms, you might call it alcoholism. It's a tendency to
Okay, what
drink
do I
too
have
much
now?
and
What's
have
it
some
called?
kind of consequence in your life as a result of your substance use.
What's the nice
And
new name
alcoholism.
for alcoholics?
It can be depending on how much you drink and then how often you drink.
That's right.
All that is something that you would consider in diagnosing.
Yes.
The many people who suffer from alcohol use disorder.
Oh, Jesus.
There you go. Alcohol use disorder.
Are they in
Alcohol
denial?
use disorder.
I would say that is one of the stages of alcohol use disorder and amenability to treatment. So in denial, it's because you do not want to acknowledge that there are consequences from your use, because in doing that, you might have to reduce how much you're using. So
Oh,
to
God
deny
forbid you
use
just call
that,
it
you feel that
denial.
you can continue your use without having to change that. So you want to maintain the access to the
You
substance.
don't have a problem.
That's right.
is the difference between traits and a diagnosis?
Well, we all have personalities. And so you're going to
Well.
have coping mechanisms that include personality styles. So for instance, even though you might not be diagnosable as something, there are times when if you're upset, hurt, frustrated, you have a mood state that's unpleasant, you're going to deal with that by using some kind of coping mechanism. So traits of personality disorders might be present in the way that you deal with inner pain, things that you don't like feeling. So some people, for instance, if they feel uncomfortable, they may cling too much or become excessively bonded to try to escape a feeling that they don't like. And that might be a dependent personality trait. It doesn't necessarily mean that they have a personality disorder, because that would have to be pervasive across like all the environments. But when stressed or upset or not feeling good, you're going to use some kind of coping mechanism, and that might be one of the criterion, for instance, of the personality disorder. You would call it a trait.
And is it your understanding that this trauma that one suffers from repeat domestic violence can cause one to be considered suffering from the syndrome, we call it battered spouse or battered woman syndrome?
Yes. So the diagnosable condition would be PTSD or post-traumatic stress disorder. That's how a clinician would label the response to trauma. The pattern between partners, the person's coping mechanism because of that trauma, that would be what's considered battered spouse or battered partner syndrome.
And you're aware that that concept of being traumatized by the battered spouse syndrome or the post-traumatic stress is relevant to a self-defense case?
Yes.
In a criminal context.
Yes, I understand that.
Can you tell us a little bit about that?
Well, under the battered spouse syndrome, the person would experience a trauma or a situation in which they feared harm. And based on that fear of harm, they would react in a certain way that might not be understandable to other people. So their fear is based on the pattern of behavior between them and their partner. That might not be the case for another set of people.
Now, I know that Dr. Lenore Walker is the one who first uncovered this syndrome back in the 70s.
Her research study generated the term. She was interested in why battered women specifically at first, that was what was studied, didn't leave their partner because of course they're experiencing traumatic events, risks to their life, but then they didn't leave. So she undertook the original research study on that.
And just briefly touch on, because I know Dr. Brandon has this, there was a 3 stages that Dr. Walker developed for that syndrome.
I think you're referring to phases that a person may go through, or the cycle of the relationship. That includes the tension building phase, in which there is the first instance that tension is building within the partner. There might be a change in tone, a signaling that there's a difference in agitation. The second is the true battering event. So something has happened between the partners that's violent in nature. And then third, there is the honeymoon phase, which is to keep the relationship intact. The batterer would engage in what's like called honeymoon behaviors, like trying to repair the relationship, apologize, essentially keep the victim from departing from the relationship. So those are 3 phases.
And is it fair to say that psychologically the abuser, does alcohol often involved in the abuse?
Yes.
And as far as the victim that's getting abused, and you say it's a cycle, is the victim, when they go through that last stage, the honeymoon stage, are they thinking, okay, it's going to be better?
Yes, the hopefulness in that, trying to believe that the behavior has changed, that they're not going to be abused again, the hopefulness to maintain the relationship, to forgive. That's part of that last stage, phase 3, is maintaining the relationship.
I don't think I've asked this. Why would someone who has been exposed to intimate partner violence perceive the likelihood of a new violent event about to appear? Why would they perceive the likelihood of that violence differently than, say, a normal person?
Well, it speaks to the pattern. So any relationship will have its own special pattern, that you have things that only your partner knows about you, or certain looks that you give that mean something, and you learn that over time. So over a period of incidents, basically, the victim begins to perceive cues that would signal impending danger. Those cues could be really subtle, just a change in tone or some small behavior that might not mean much to another person, but it has preceded other violent acts. So for instance, if your husband decides that he is not going out that night. He might put on different clothes to stay home. And that could be a signal, like abuse and violence has occurred in his stay-at-home clothes, for instance. That might not mean much to another person because, again, it's specific to that dyad. Those two people know those patterns. So the victim may perceive a small or subtle change in their partner as a cue because they've become hyper vigilant. The body knows when it's experienced a threat to itself, and it will take note. We record memories differently when we're at risk. So these subtle cues become very well memorized by somebody who's being victimized.
Now, on this, and battered spouse syndrome is a subset of post-traumatic stress disorder, which you diagnosed Sarah Boone with. When those personality changes occur and they persist after an individual has been exposed to this extreme stress, is that when the diagnosis occurs?
The changes would be as a result of the pattern. The person experiences a change like in their sleeping, in their hypervigilance. That's when you can diagnose it. So you can have a trauma or an experience of, scary incident, but it doesn't mean that you will absolutely have post-traumatic stress disorder. You have to have those reactive symptoms that would suggest that it's present.
In your opinion, and I know you've gone over this event with Sarah Boone, this February 23rd, 2020 event, is your opinion that she was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior that would be typical of a victim who's responding to traumatic events in a predictable way. So that would fit that.
And it's fair to say that because of the intimate partner and the prior violence, that you would have a heightened sense of when danger was about to occur.
Yes.
When a threat was about to occur.
Yes.
Threat of danger.
That's right.
Now I want to talk about placating the abuser, a victim placating an abuser. Are there predictive cues which an abuser may exhibit to a victim that result in a high level of anxiety arousal in which the battered woman may attempt to reduce through several different means to delay the beating? Can you explain that?
Yes. So the phase of the relationship that starts with that tension building, that is a jumping off point potentially. So if you can stop the escalation, you might stay in phase one for a period of time. Phase one being that tension building phase and trying to reduce it and not allow it to escalate. So placating the abuser might include distraction. It could include substance use. It could include a change of scenery. There are a lot of things that a partner will learn to do so that they don't have the escalation into an abusive event, if possible. It doesn't always stop it.
Now, in reviewing all of the data, all the reports, medical records, and whatever reports you considered, videotape that you may have watched, as it relates specifically to Sarah Boone, are her words her power?
Her words, I would say, are the weapon that she has.
Explain that to the jury.
In reviewing the available videos that I had to review, you would see that when Ms. Boone is very stressed, when she's experiencing a high level of anxiety, she becomes short in her tone. You can hear that in her voice. There's strain.
Like all the time.
Sharper words come out.
All
I think
the
that
time.
is the way that she would try to respond to Mr. Torres. You can hear that sharpness in her voice when she's very stressed out.
Now, would you agree that victims may exhibit a range of behaviors when they're suffering from intimate partner violence?
Yes.
Self-isolation,
Yes.
suicidal thoughts,
Yes.
substance abuse,
Yes.
and there are often physical signs of injury such as bruising,
That's correct.
chronic fatigue,
Yes.
learned helplessness.
Yes.
Can you tell, I know Dr. Brandon spoke on it, but could you tell us a little bit about that?
So learned helplessness is when you start to form the opinion that nothing's going to make any difference. It comes originally from an animal study in which dogs were shocked. And the research study indicated that even when dogs were given an opportunity to escape the environment in which they were being shocked, if they were shocked enough, they just stopped trying to escape. So even though they had an opportunity to do so, they did not do that. That's called learned helplessness. It's the idea or belief that what your actions are going to do are not going to make a difference. So don't try.
What are intrusive memories?
Intrusive memories are an element of post-traumatic stress disorder in which you don't want to be thinking of a traumatic event, but it intrudes on something else you're trying to do. Like maybe you're folding socks or something like that, just doing something mindless, and that's what takes over your thought process. It's not something that you're trying to think about. We could plan what we're thinking about, or sometimes if you're just having this intrusive experience, that's not what you were intending to think about at all.
Is that one of the conditions that someone may suffer when they have this syndrome of battered spouse?
Yes.
I know there can be triggers that bring on these memories. Am I correct?
That's correct.
Are there also symptoms of this syndrome where, like in the alcoholism, where you have denial that you're in the middle of this cycle?
Well, as part of the relationship, there's an element of pleasure. Like you have early on in the relationship something that binds you together. So you're remembering that, you're hoping for that. Even though the repeated cycle is going through the phases 1, 2, and 3, you keep hoping for elements of that honeymoon phase, wishing that it was better. So it is like denial. You're imagining the way it used to be. You have a recollection of that person showing you positive behaviors, and you're hoping for that. I also think it is typical for victims to not reveal to other people that the abuse is going on. And it seems like denial. In other words, your coworkers ask you, like, are you okay? Did something happen to you? You're not likely to disclose that. That looks a lot like denial. It is a denial in public of some of the private
Denial's a river in
that you're
Africa,
having
lady.
in your relationship. And that's because it's embarrassing. It's revealing a loss of control to other people.
I've
It's
been
revealing
keeping that in
things
for a
aren't
long
perfect.
time. I couldn't
You might
quit
even
any
get
longer.
feedback that you should leave your partner, and that's unwanted because you're already having that
Get her out, then.
concern in your own mind about it. And so, it seems like denial on the outside to hide it.
Would you agree many people who suffer from this, they're minimizing what is happening to them,
Yes.
and they're numbing their emotions to it?
Well, to stay present and keep that relationship, it's very difficult for a lot of people because they're experiencing physical and emotional harm. So they want to numb it, because numbing it means that you can keep that relatedness no matter how bad it's getting.
Does some people with this syndrome disassociate?
Relevance. Approach.
All right. While they're approaching, a couple things here, then we'll skip through it. Island with the $2. Nothing to say. I just love those little tater tots. Yoda's the sleeping tater tot there. Legal and signs. The internet's a weird place. I heard there's a big fire in Busan at the U.S. military base. Can you see it? I don't know where you are, but it's weird that I'm learning about things happening in my own city on the internet. I just Googled it, and it wasn't. There's
Objection relevance is overruled.
There's not really a base here. There's a pier and a storage facility. This was at the storage facility. It was just a big fire. Looks like it started in a 40-foot refrigerator container, and then sort of spread. So yeah, nope, can't see it from my house. There's a mountain in the way.
I mean, look, if it makes you feel better learning about things about your own place on the internet, I only found out about 2 hours ago from Twitter that there was a stabbing near my house. So
yeah. Well, this is like probably 5 miles, like 7 kilometers or so from the house. Anyway, and one more Jessica loves is, can you share where you got your pipe made from? I'd like to get one for my ex-husband for Christmas, from our daughters. Thank you. The guy that made this is he's a master pipe carver named, he goes by Downey Pipes on Instagram, but he's got about a 1-year waiting list, and
damn,
this is ridiculously expensive. Ridiculously expensive, because he's good at what he does.
Kidding.
Yeah. I've had this well before the YouTube days, so none of your hard-earned super chat money went to this. But this was $1,400. So yeah, he's one of the best in the world at what he does. But there's other places you can get pre-made pipes in various shapes and things. Just Google something, and you should find something.
Do you agree that battered women often develop the defense mechanism of being able to psychologically detach from their body during a traumatic experience?
Some people do experience that.
This is also the guy that made the Raven pipe I was smoking the other day.
I'm just going to list
Those are
some of
much cheaper.
the symptoms that you find in battered spouse women, and just to see if you agree with these. We talked about intrusive memories and flashbacks of the past traumatic events. You agree with that?
Yes.
The severe anxiety and hypervigilance,
Yes.
the panic attacks,
That is sometimes present. It depends on how the person experiences anxiety, but some do have panic attacks.
very low self-esteem,
Yes.
poor body image,
Sometimes.
feeling that they have no control,
Yes.
sexual dysfunction,
It can be, particularly if the trauma includes sexualized attacks.
short-term memory problems and confusion,
Yes, that's part of PTSD sometimes.
and they can actually have physical health problems from the chronic stress and physical violence.
That's correct.
Fear,
Yes,
constant fear.
that's correct.
Constant.
Now, the abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting.
Approach.
All right, it's a relevancy objection, which we can fast forward through because there's nothing else to talk about right now. It's a long relevancy objection.
Partner, I'm asking about common things that occur by the abusive partner towards the victim that create this intimate partner violence or create this syndrome in the woman. Hitting,
Yes, that could be an overt act.
kicking,
Yes,
punching,
yes,
choking,
yes,
burning,
yes,
using weapons to hurt you,
yes,
a knife,
correct.
curtain rod,
Yes,
threatening to hurt you, your children, or your pets,
yes,
belittling and humiliating you,
that's correct.
taking your car keys,
That would be considered a form of control. So yes,
controlling your money,
yes,
control where you go and who you see
correct.
and who you can talk to,
That's right.
force you to have sex when you don't want to,
Yes,
Oh, so now they're going down the R word path, are they?
stalking you,
yes,
slapping you,
correct.
Do you agree victims that suffer from this abuse experience feelings of anger,
Yes, that can be in some of the phases. So
sadness,
Can
Yes.
be.
hopelessness,
yes,
worthlessness,
correct.
intense feelings of fear?
Yes,
Abusers have a tendency to have low self-esteem themselves.
Overruled. Overruled.
The abuser can have low self-esteem himself,
yes,
have a desire for power and control,
correct.
have a tendency to use alcohol or drugs.
Yes,
Yeah, did she have any of these
Abusers
symptoms?
oftentimes have temper,
that's correct.
Did he
Becomes
have
jealous
any of these
easily.
behaviors?
Yes,
very possessive,
can be.
He did art and puzzles and went to feed the ducks across the way. That doesn't sound scary.
the victims can suffer from severe psychological distress.
That's correct.
Is that what Sarah Boone suffered from?
Yes,
Yes.
Okay, more approaching and stumbling around. There we go.
Exhibit 14, this is 5 photographs. Did you watch the video of the TV, the Battered TV?
I did.
You considered that in your analysis and your diagnosis?
Yes, I did.
I'm going to show you some pictures. Exhibit 12. I believe she's testified to scoring curtain rod. Are you familiar with that?
Yes,
Exhibit 11, are you familiar with this photograph over here?
yes,
Exhibit 10, which is her arm. Are you familiar with that photograph?
yes,
Exhibit 9, picture of the bloody knee. Exhibit 8, picture of her black eye.
Yes, I've seen this.
Picture, Exhibit 7, picture of her Sarah's lips and like her eyebrow.
Yes.
And this is a deposit Exhibit 6, which is of the staff to a button. You agree with this?
Yes.
And I don't know if you've seen this, Exhibit 5 is where she spilled some soup as a result of his behavior.
I'm not sure if I've seen this photo, but I've seen a medical record associated with that.
Of that burn.
Yes.
Exhibit 4,
Yes.
agree with that? Was like Exhibit 3. She was slapped on the tongue.
Yes.
2, which are bruising in his book.
Yes.
Did you consider all those photographs informing your opinions that you've expressed here today as it relates to Sarah Venn?
Yes. Under the substantiation that she has indeed experienced past instances of intimate partner violence against her.
Is it fair to say that it takes time, a number of times to visit with someone like this to build trust?
Yes. Traumatized people are slow to disclose information. You have to build rapport. You have to make sure that they experience you discussing other things without an emotional
read any
reaction.
of her
They feel
letters?
easily judged, as we mentioned, have defensive denial, things like that. So you need to build good rapport in doing an assessment with somebody that's experienced trauma.
So a lot of times they're very slow to open up and tell you about the abuse.
That is correct.
And they'll actually often lie about it.
Deny it, yes, and just say that that's not the issue or they're fine. So oftentimes I'll have an evaluation request come from an attorney who's having difficulty interacting with their client, and then ultimately it's a result of trauma.
Now, I know that you viewed everything and I know you've seen her 9 times. Is there any, did you feel like you had enough time? Was 9 visits enough time for you to feel like you had enough time and information to form the opinions that you've expressed here today and give to the school?
Yes.
That's all the questions I have.
Wow.
Cross-examination.
The state better tear her apart. That was bad.
Maybe I'm just dumb, but I heard very, very little saying this is what I observed in her. I heard a lot of this is what it is, and these are some indicators, and these are some traits that perpetrators may have. I heard shockingly little of this is what I observed from her, and this is what I learned from her.
Yeah, she basically said, in my opinion, she has PTSD, and here's a bunch of things that apply to other diagnoses that are unrelated. And the thing that annoyed me is she actually, at one point, was she actually saying that PTSD and narcissism are mutually exclusive? Like you can't have a diagnosis of both?
Honest to God, I don't really know what she was saying. She said a lot of shit that made me go, huh?
Okay, fair enough.
I really can't tell you. For a while there, I was thinking, holy crap, I have battered spouse syndrome and I'm single dude. Like depression, anxiety, like she was listing off these things. I'm like, oh my God, it's me. But
Has
wait a minute.
Straws been stealing your keys to keep you under control in the house?
Spit it out, dog. You're the abuser. You're the abuser. Oh no, you have a red nose. I didn't do that. She just did it from scratching.
Now you're worried people are going to accuse you of abusing the dogs.
Yeah.
It's mutual abuse, people.
Come here, baby.
Oh,
we need to.
she's
All
okay.
right. No, you gotta keep those folds like dry. Apparently, there's like a little bit of redness underneath one of her eye folds. All right, I gotta clean that up. Get him, Tiger.
Harper.
Good afternoon.
So you have done some evaluation work on battered spouse syndrome for a prosecution in the past?
No,
All right.
You
Have
just
you done
yes.
insanity evaluations for the prosecution in the past?
I have been called to testify about that.
So you understand when the government obtains a court order for their expert to
Now
come
I
in
owe
and do
Strawberry
an
a treat.
evaluation,
I'll
it's
be
for
back.
one evaluation, correct?
I believe that you're saying that the government can retain their own expert. Yes,
No, I mean, what I'm talking about is you just went through that you had 9 visits with Ms. Boone,
I
correct?
did. Yes,
And that was over the course of 8 different days because 2 of those visits were morning and afternoon sessions, correct?
that's right.
And what we are trying to help
defensive.
you have the jury understand is that when you get hired by the government and the court gives you an order to go evaluate somebody, you get 1 crack at the apple. Is that your understanding from your past work working for the government?
No, that's not always correct. There are many instances in competency evaluations where evaluators will request additional visits if they cannot determine their opinion on the first visit.
All right. Specifically, when it comes to an affirmative defense, such as battered spouse evidence and insanity, what is your understanding and your expertise?
What is my understanding of the issue? Oh,
Judge, the question.
Legal objection.
Objection?
Legal grounds.
He asked a question about battered spouse and
Approach.
Grounds. Yeah. Oh, he's like, hey, I didn't ask you for a dialogue. I asked you for legal grounds. And then he started giving an exposition. He didn't know. Get up here. I would say that qualifies as judge as judge shows emotion. that was a counselor get up here kind of thing.
Judge shows emotion.
Objection sustained.
When it comes to an affirmative defense, such as battered spouse syndrome being used for self-defense or not insanity, it requires a court order for the state to go have an evaluator go, right?
yes.
All right. Now, what are the agreed upon criteria for battered spouse syndrome?
Well, you would evaluate if the person is indeed suffering from a behavioral response, like a mental disorder. So first of all,
And judge calls for sidebar. Mark that off too. But also very interesting. Great success brings up a question. This is normally the first question that is asked of experts. How much was this witness paid? It's just it's either usually the first or the last questions. I don't even know if he's going to ask it, but good for him for not even asking it, because everybody knows these people get paid.
has the person demonstrated that they've got a behavioral change, and is it in response to a violent act? Do they perceive threat?
Of course I do. It's
where
almost
they've
finished.
been exposed in the past? So pattern of violence that has repeated.
Does control over another person in an intimate relationship have anything to do with it?
Yes, it can.
Does isolation have anything to do with it?
Yes.
And by control, I mean controlling who you go see, who you hang out with, so on and so forth.
Yes.
And could it involve
Walking
controlling
into a
personal
trap.
items of the other person as well?
Yes, it can.
So that's what I'm asking. Like in the DSM-5 TR, I believe you pulled up narcissistic personality disorder.
Yes.
And so when you do that, it pulls up and it says there's 9 criteria and 5 of those criteria must be met to make a diagnosis for narcissistic personality disorder, correct?
That's right.
Now, battered spouse syndrome is not recognized by the DSM-5 TR, correct?
No, it's not a diagnosis. You wouldn't use it as a diagnosis.
And what I'm asking is, even though we haven't written it down in the Diagnostic Statistical Manual, and I mean the like the Ohio State University or something, is it written down anywhere? Can one psychologist or psychiatrist rely upon a recipe or a list of criteria that everyone else would be using in your field as well?
There is no standardized approach you must follow. In other words, sometimes if we have a statute, for instance, it would identify what we must investigate. It doesn't exist like that. There's no statute directing it.
And there's nothing written down anywhere that says, of these 9 criteria, these things must exist. Controlling your partner, isolating your partner, beating your partner, so on and so forth, correct?
That's right.
All right. Now, this kind of abuse can come in the form of emotional or mental abuse outside completely of physical or sexual abuse, correct?
So that is a component. You can have extreme mental abuse occur of a person. Yes.
And if that person responds to that environmental stimuli of whatever it is the partner is saying or doing to them, they may internally view that as traumatic,
They could.
or they may not.
That's right.
It's entirely possible for 2 people to be in a 3.5-year relationship that has physical violence and neither one of them feel traumatized by that. Is that correct?
That's right. If they have enough supportive or positive experiences that would negate that ratio, so of positive to negative, they may feel okay.
And a man can be subjected to this sort of trauma, whether it be physical, emotional, or sexual by an intimate partner as well, correct?
That's right.
And
Good
it's
question.
basically it's unique to each relationship, right?
That is right.
But trauma is in the eye of the beholder. Is that fair? Whether a negative experience traumatizes somebody is going to be in the eye of the person who experienced that stimuli, correct?
I only partially agree with you. It's a complicated answer because some of the manifestations of trauma are behavioral. So for instance, when I evaluate veterans who have returned and they may not know that they've been traumatized, their bodily responses that include like difficulty concentrating, they can't sleep, they're hypervigilant. The PTSD diagnosis encompasses outward manifestations. So
okay, this is a problem I have with psychology
Okay.
and psychiatry in general. And
Right.
maybe it's because I have very limited experience in dealing with it. But this, you have this disorder. You don't know you have this disorder, but you do. I think you have to be very, very careful when someone says, you have this problem, but you just don't know it. I don't like she's
Well, I
going
mean, on the one hand, I agree with you. On the other hand, that would destroy the entire premise of 8 seasons of House.
Well, I mean, okay, here's your symptoms, and we have a name for it. This is what it is. You didn't know this is what it was called. But she's saying they are not aware that they even have these things.
Again, I can understand why you wouldn't, though. I mean, if you're a complete and utter diagnosable narcissist, you're not going to know that your head is up your ass. So,
I'm framing this wrong. I know it's like, okay, someone says, I've dealt with this, and this my entire life. And they go, oh, we have a name for this.
Mm-hmm.
Rather than someone saying, well, you're suffering from this. Now let's go backwards and show you why you're doing this. Sort of a confirmation bias, or you lead it. I'm a product of the early 80s, the satanic panic thing, where it was,
okay.
All of that was happening, where it was, oh, you were abused. You just don't remember it. Let me help you recover those memories. That's where I get leery when you don't realize this happened to you. So let me refresh your memory. That's where I think we have to be careful.
I think that's fair. I think the tests for malingering and for various other things sort of weed a bit of that out. But I agree with you that obviously we've got to be careful with. And let's face it, we all know that Boone's full of shit. So yeah.
Well, they're diagnosed by psychologists and psychiatrists. So you were suffering from this, you just don't remember it. I know that's not what she's doing here. Extremely Happy Simmer says that's not what she's talking about. But the hair starts to rise. I start to get a little suspect when we start talking about things that we can't remember or don't know. Anyway, let's just continue.
Only partially agree with you. It's a complicated answer because some of the manifestations of trauma are behavioral. So for instance, when I evaluate veterans who have returned and they may not know that they've been traumatized, their bodily responses that include like difficulty concentrating, they can't sleep, they're hypervigilant. The PTSD diagnosis encompasses outward manifestations. So even though they don't acknowledge trauma, you can still identify it as a clinician.
But still, somebody like a homicide detective or a homicide prosecutor can go to scenes where there are dead bodies, go to autopsies where there are dead bodies, and not walk away with any trauma, correct? Whereas somebody else might.
Right. The environmental, cues for that person, and also working with law enforcement, they become seasoned to micro traumas. So the first, almost every police officer can remember the first dead body they've seen. So it's in their memory. And then they become accustomed to seeing gruesome scenes. They have increased tolerance over time because it's part of their job. It may not be part of their intimate relationship that they have.
So just say they become desensitized.
Is something common with PTSD with veterans, something like firecrackers may set them off because it reminds them of acts of war.
That's right.
You're not suggesting to the jury today that if somebody who returns with PTSD from service and hears firecrackers is justified in going outside and just shooting bullets everywhere, correct?
No, that's not what I said.
I'm not saying you did.
Okay.
What this battered spouse syndrome evidence is
my life is a micro
is not that subjective mindset, but rather helping to explain the objective circumstances
mindset
that are presented to somebody and how it might be different from somebody with those experiences. They may view something objectively different.
I partially disagree with your question because I would say that there are incidents or actual events between partners that would be a factual thing, something has happened. And then the person subjectively experiences that as, intrusive or controlling or traumatic. So that is the person's felt or subjective experience. The objective part is what happened.
But again, as a forensic psychologist, you're familiar with the justified use of force instruction, correct?
I'm not a lawyer though, so I'm aware of it, but I cannot debate fine points of that with you. I'm sorry.
I'm just helping, I'm trying to understand what you said before. Is there a subjective component, whether or not a person believes subjectively that they need to use some sort of force, deadly or non-deadly? You agree with that, correct?
I do.
And then there's also a second component that it's objectively reasonable to the ordinary person to use force, correct?
I understand what you're saying, yes.
And what I believe I heard you mention earlier about battered spouse syndrome was originally was meant to help understand why people stay in these relationships.
Originally, yes.
Because it may not just be intuitive to somebody who doesn't understand these things, why somebody who is abused time and time and time again would remain in that relationship, correct?
That's right.
And again, and I know you're not a lawyer, but if the law has evolved about retreat and not having to retreat and so on and so forth, that kind of changes some of the lens of this, correct?
Judge, I'm going to object.
Approach.
That calls for a legal
Question
opinion. I'm not happy with that.
All right. So you would agree that hypothetically, if somebody is running down their partner, saying negative things about them, telling them they're unattractive, telling them things that would potentially hurt their feelings, that could be an element of control of a verbally abusive relationship.
It could.
Propping one up, hypothetically saying, I'm the best thing that has ever happened to you, you'll never do better than me. Is that a potential component of the control that one in an abusive relationship might exert over an intimate partner?
Yes, to try to not encourage their partner to leave them. Yeah.
Considering gifts, hypothetically, that one partner has given to another partner, but considering it still to be your property because you gave it to them, is that a form of a potential exertion of control over an intimate partner when you give somebody hypothetically a bike, but still consider it your own bike?
I mean, I don't think that's strong evidence of that. I think that it does happen in relationships and people do that in general, but I wouldn't say that's like really specific to this.
How about hypothetically exerting control over your intimate partner's identification papers, such as a birth certificate?
So that can happen. People will hide things that are required for work. For instance, like your driver's license or things like that.
Now I'm asking yes or no questions. If Mr. Owens would like you to elaborate further, he's going to have that opportunity in a little bit.
Oh, lawyer's getting testy.
Hypothetically, if one partner destroys another partner's belongings, is that a potential example of exerting control in a relationship?
Yes.
Thank you. Hypothetically, is threatening to or actually using legal process as a threat against your intimate partner in a potential indicia of controlling your partner. For instance, X, Y, or Z, or I'm going to get you arrested.
Yes, I would agree that happens.
I do like how he's not really attacking her diagnosis of Sarah. He's building a case for George being the victim. I like this.
Yeah, my only query though is that I don't think he was understanding that him talking about the subjective nature of PTSD and how someone may view certain actions was not as helpful to him as I think he thought it was. If anything, I feel like that was like a half a point towards Sarah because the jury may be looking at that and going, well, okay, how did she feel in that moment? There is a subjective component to it. And I think he harped on that a little bit too much for what he was trying to go for. I think that might have hindered him a little.
I assume you would agree that the cycle of violence that we've described, the tension building, the blow up, and then the honeymoon phase, you would agree that just one of those cycles could be enough to give somebody a traumatic experience if they took it as a traumatic experience.
Yes.
The defendant described her first date with Mr. Torres to you, did she not?
She did.
And at the time of this first date, they had obviously just met that night at a bar, correct?
Right.
They were not financially intertwined, correct?
That's right.
They shared no children in common.
That's right.
They did not live together.
Correct.
And after this description that she provided you, which included him smashing her phone, correct?
Yes.
Hitting her, first time she'd ever been hit in her life, correct?
Yes.
And making her crouch in like a fetal position on the porch for several hours to the point where it hurt her back, correct?
Yes.
Threatened to sodomize her.
Correct.
And she described that she was all bruised up, correct?
Yes.
After that, this is the first time she had ever met him, correct?
I believe so. Yes.
There was a second date, correct?
Yes.
Despite not having any of that intertwinement that we went through prior to this description, correct?
That's right.
Now, it is possible under what we've discussed, right? Just that quick one date can be that buildup of tension and blow up, correct?
Yes.
But it's different hypothetically than saying a spouse who is financially dependent on his or her other spouse in a 20-year marriage with a house full of kids than a first date, correct? You would agree in severity, in the intertwinement, there's a difference.
There's a difference in intertwinement. The pattern can be exactly the same.
Now, of course, there are many different reasons why somebody will stay in a relationship that, when perceived from the outside, others would say is abusive, correct?
That's correct.
The defendant described that she felt like she was making Mr. Torres a better person, correct?
That's right.
A better father, correct?
Right.
A better ex-husband.
With phone calls. Yes.
And she would tell him to call his children,
That's right.
make sure that he sent them Christmas gifts,
Yes.
and make sure he sent his ex-wife money when she asked, correct?
Yes.
So you would agree those are indicia, or indicators, sorry.
Understand?
I know you knew them. That perhaps she wasn't necessarily financially dependent on Mr. Torres, correct? I'm not saying conclusion, but those are indicators. If you're saying, please spend your money elsewhere, that I don't need your money, correct?
No, because even if there was money that was needed by Ms. Boone, her tendency to put the needs of her partner before her would direct her to do exactly that, like make him better, make him have the availability to visit his children, send them presents, even if she's the one that needed the money.
And in her perspective, Mr. Torres needed her to do this to make him a better person, correct?
I believe that, yes.
How many years of her adult life did she describe working?
I don't think she gave it a specific quantity. We just went through a variety of her jobs that she had in the past.
And, she was low 40s when she met you? 4 years ago?
That's right.
So she'd been 18 for probably about 24 years. Did she give you a 24, right? 24 plus 18, 42?
Oh, you said for 24 years, and that's why I was confused. You can't be 18 for 24 years, but 24 years ago, I would agree.
Did her work history kind of flesh out to be 24 years is what I'm asking?
I'm not certain.
And at the time, in the apartment in 2020, she had not been working, correct?
That's right.
And had not been working for some time.
That's right.
And what she was doing was living off of the settlement that she had been bought out of with her husband, was lump sum, plus $1,000 a month in alimony and $100 a month in child support, correct?
Yes.
And it was Mr. Torres who would work, correct?
He worked at Ace Hardware.
When he would show up.
Right.
Sometimes he didn't show up, is what she indicated, correct?
Yes.
Because of his drinking problems.
Yes.
Did she describe to you, well, let me strike that. She did describe to you one instance, at least, where violence occurred in front of her child, correct?
Yes.
And that her child had gone to school and reported it, correct?
Yes.
And you understand as a forensic psychologist that teachers are mandatory reporters, correct?
That's right.
Did you review any DCF records in this case?
No, I didn't receive any DCF record.
Did Ms. Boone ever indicate to you at any point in time she became too afraid to let Lucas come over to the house?
Yes, there were times where she would ask Mr. Boone, so Brian Boone, to not bring him there.
And Mr. Boone was aware of this because she would say things like that, correct?
Yes.
And at different times, she told you that she would go over to Mr. Boone's house to escape the violence of Mr. Torres.
That's right.
And February 24th of 2020, the child was scheduled to be picked up by Ms. Boone, correct?
That's right.
Despite everything that she was aware of and what Mr. Brian Boone was aware of, correct?
Right.
And you saw in her police interview that she swore on the life of her son that she was telling him the truth, correct?
Yes.
Yes.
Object.
Approach.
Approaching. Well, it's time to bust open the forbidden snack tray. I get to drink the juice box that Sarah can't. Capri Sun orange. All right, let's get through this. Let's fast forward. Nope.
She swore.
Objection sustained.
Or phrase it. She swore on her son's life that it was not intentional that she ended up killing Mr. Torres, correct?
That,
That was quick. So she swore on her life it was not intentional. Intention is part of her defense. She intended to do it, but she was justified.
Are not evidence, and you're not. Objection sustained. Question is stricken. Members of the jury, questions are not evidence, and you're not to give them any weight whatsoever. Mr. J, you may proceed.
She's quote unquote swore on her child's life that it was not intentional. That. Correct?
Before I answer, I'd like you to direct me to that part of her interview. So
I'll strike with you. It's a bit. Some of Ms. Boone's diagnoses predated her relationship with Mr. Torres, correct?
yes,
And so when diagnoses predate a violent intimate partner relationship, there is an independent cause, even though they may then later contribute to phenomenon, correct?
well, I wouldn't say that all mental disorders have an independent cause. Sometimes they're spontaneous or biological in nature.
Well, let's talk about hers. I mean, you're familiar with her prior diagnoses, and you went through her childhood, so on and so forth, correct?
I did.
So she was bringing some things with her prior to Mr. Torres' relationship, correct?
She had these.
Answer yes or no, ma'am.
Yes, she did.
Thank you. You reviewed some Advent health records, correct? Of hers?
Yes,
And some Aspire records of hers, correct?
yes,
And you would agree that there are times in the Advent health records where she goes to the hospital and then leaves before getting treated, correct?
yes,
And there is
Boontang
a time
induced
when she goes to the
restroom disorder.
hospital
I'll be right
where
back.
she is described, their words, not mine, as having ETOH on board.
yes.
Do you understand what ETOH means?
In a medical record, you would use that shorthand for alcohol.
Or ethanol, right?
Yes,
Drinking alcohol, not the other stuff.
correct.
Yeah, it'd be a little bit
And
problematic if she had rubbing alcohol in her
records
system.
that you reviewed from Aspire. She came with complaints of depression in January of 2018, correct?
That's right.
And ethanol or alcohol is a central nervous system depressant, correct?
Yes,
And I know you're a psychologist, not a psychiatrist, so let me know if I'm pushing you too far and you're not going to answer. But you are familiar generally with the effects ethanol has on the body.
generally, yes,
And you diagnoses of alcohol abuse disorder.
I do.
And in your professional life or personal life, are you familiar with the standard serving size of drinks when you're evaluating somebody's drinking? For instance, hey, I only drink 2 drinks a day. All right, well, are they 64 ounce mugs of
Objection,
beer or
outside the
12
scope of her
ounce? So are you familiar
experience.
in that context?
It might be a question I would ask during evaluation. What are you referring to? Is it a mixed drink? Is it a shot? I try to identify that.
Have you ever asked if somebody says they drink 2 glasses of wine, well, how big are the glasses of wine?
Sometimes.
And is your understanding that 5 ounces is the standard serving of wine since it's about 12% alcohol?
I'm not sure what the standard size is, but I would ask regarding like a wine glass.
And in January of
She's
2018,
just being
when she
she's
came
being
in
difficult.
crying and complaining of symptoms consistent with depression, she had a blood alcohol level of 0.165, correct?
I believe so.
And
Nice.
in October of 2018, when she ended up going to Aspire, when she was found stumbling by police, she had a blood or breath alcohol of 0.185.
I'm reacting to your description of her stumbling by police. I know she approached police for help. So
Seeds fan 85 with the $5 Australian says the shrink comes across as one of those believe all women and men can be victims
That I
people.
received on September 27th.
She did say men can be victims.
Can you turn to
Good for
page
her.
21 of 57 of the Aspire records?
mine aren't numbered, but I will.
May I approach the witness?
Yes.
While he's approaching Pope Rackets touched me member for 7 months says if she gets acquitted, bravo defense attorney. However, time to pack away those assault suitcases, leave the nut house, and don't let your partner pack you up. And extremely happy Simmer says, I have a friend with schizophrenia who thinks she's fine and nothing is wrong. It's 100% possible to think you're fine when you're not. Of course, I mean, that's part of schizophrenia. What I'm talking about are things like when she said people that suffered from trauma that don't know they suffered from trauma. That's when I said it just kind of sets the spidey senses tingling. And that's why I said we have to be careful what she's talking about. We're not talking about things like that. I was just saying you have to be cautionary when people will come and say you experienced something without knowing you did it.
No, look, when you phrase it like that, I get it. I understand it. It's you when someone experiences a traumatic experience, but they don't realize that it was a traumatic
What I'm
experience.
showing you is what is
Yeah, and that's what she said.
page 21 of 57 on records from
That makes more
Aspire,
sense.
provided to me by the defense on September 27th, 2024. And just at the top, you read the first to the fourth lines.
All right, Judge, I would ask that she be allowed to read that entire paragraph. Under the rule of completeness.
Approach.
Did somebody say she was violating her oath?
Boosh.
Bush. Spoiler alert, people. Ignore the vast majority of what Bush says. You'll get used to him after a while.
Rough but fair.
I love you, Bush. But it takes people a while to get used to you sometimes. All right, let's keep going here. Now, extremely happy simmer. No name calling, please.
In October of 2018, or of 2018, there was a second visit to Aspire, and that was based upon her being found stumbling by law enforcement with a .185, correct?
0.185.
And that's
She walked up.
Damn.
Okay. So I'd have to say no, the way you phrased the question.
Ma'am, Boone was stumbling due to her level of impairment, paren .185.
Yes, I would agree.
Is that part of the records you relied upon?
Yes.
Thank you. When you talked to Ms. Boone about that, she kind of just described an event of June of 2018 and blurring those two events, did she not?
No, she told me she had two different Baker Acts.
Did she describe it as being June of 2018?
I'll have to reference my interview note to find that if you would like me to.
No.
Two Baker Acts. The reason when the Baker Act is when the cops go, we're gonna take you away for 72 hours for your.
I do.
And
For your safe being and everyone
at
else's.
that point in time, and I'll ask, opposing party, you want me to show her prior statement before I ask her about
I
it?
think she's got a deposition.
Do you have your trunk?
Oh, David Cole, it was never going to be anywhere near a world record. Hell, we just watched a video where someone hit .235.
For the record, it's page 34 that I'm referring to. Line 16, 17.
Yes, I'm with you.
Her ears are really, really red.
2018.
That's what I said in my deposition, that she was describing her experience in June of 18.
And she described this experience as going to the hospital to find a pastor, correct?
Yes,
And ends up going to what we call Lakeside then and Aspire now, right?
yes,
And then what you described was she was talking about more of the violence that occurred specifically regarding a significant episode of Jorge driving her roughly in the car, so on and so forth, correct?
yes,
All right. Those were two separate incidences. January when she came looking for the pastor, correct?
So I'm just clarifying, there's a record that we started with this conversation from October of 2018, and there is a description of her trying to go to the hospital to seek a counselor. So those are two different instances.
In January of 2018, when she went to the hospital crying and signs of depression,
Bless you.
she indicated that was because her husband and son had gone out of town and she was feeling lonely and sad about having lost her job a few weeks earlier, right?
There were numerous stressors there, yes.
Nothing mentioned about any problems with somebody named Mr. Jorge or George Torres, correct?
You're talking about January?
Yes, ma'am.
Good question. All right, while she's looking at that, there's 714 people here and 520 likes. People get down there and smash that like button and hit the subscribe button as we eke our way towards the goal for today. And also make sure you open up a separate window and subscribe to Aussie Overlord and watch his channel. He does some awesome stuff over there, just like we do here.
Yeah, for example, today we had Sov Sit Day, where we just watched body cam footage
The
of sovereign
hospital
citizens getting their butts handed to
Are
them.
not referencing her
I'll even make it easy.
relationship
Here's the link.
with George on the January date.
Now, in talking about February 23rd, 2020 with Ms. Boone, you talked to her about that on several occasions, correct?
I did.
And part of one of those conversations, at least, was about an incident that she indicated had happened the night before February 23rd, 2020, correct?
Yes.
And she indicated and told you that she had been dragged down the stairs the night before the suitcase incident, correct?
That's right.
And in part of your review of this case, you reviewed all the crime scene photos, correct?
Yes.
And those include photographs of Miss Boone, correct?
Yes.
And were there any indications in the photographs of injuries on her consistent with being dragged down the stairs of carpet?
I didn't see inside her scalp. So I didn't see photos of inside, her hair follicles and this area of her head. On her outward body, there were no indications of that.
And did you ask her how it was that she was injured during this dragging down the stairs?
I don't think I went through specific injuries to her. No.
Being a psychologist, would she be of an appropriate qualification to make comment on that? Probably not.
Do you agree that alcohol intoxication affects the credibility of a historian that's providing history to you, a patient, or a client?
If they're actively intoxicated, yes.
We had talked, you and Mr. Owens, had talked about narcissistic personality disorder earlier.
Yes.
And that is a recognized diagnosis in the DSM-5-TR.
That's right.
And there's 9 of those, correct? 9 traits?
You're talking about the criterion of narcissistic personality disorder? Yes.
Like page 761 on your hard copy?
Thank you. All right.
Was I close? I have a digital copy.
760, but
One of the criteria is has a grandiose sense of self-importance, for example, exaggerates achievements and talents, expects to be recognized as superior without commensurate achievements, correct?
yes.
2 is preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love, correct?
Yes.
3, belief that he or she is special and unique and can only be understood by or should associate with other special or high-status people, or institutions, correct?
So 3.
Well,
just
shit.
Caveat. It
I'm
says
3 for 3
belief,
so
not
far.
Belief, but the rest of what you said, I agree with is the criterion.
4 requires excessive admiration.
Yes.
5 has a sense of entitlement, unreasonable expectations of especially favorable treatment or automatic compliance with his or her expectations, correct?
Yes.
6 is interpersonally exploitive, takes advantage of others to achieve his or her own ends, correct?
Is interpersonally exploitative. I agree.
7 lacks empathy, is unwilling to recognize or identify with the feelings and needs of others, correct?
Yes.
8 is often envious of others or believes that others are envious of him or her, correct?
Yes.
9 shows arrogant or haughty behaviors or attitudes.
Yes.
Now,
Now they're just describing everyone on the bar roll.
you believe that she has traits of that disorder, correct?
Yes.
Grandiose sense of self-importance.
There are indications that she feels like that or has expressed that before.
Indications?
So that's a yes.
Yes.
Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love.
No.
You remember going to the state attorney's office on October 1st, 2024 and giving a deposition?
I do.
And it was in front of a court reporter with Madam Court Reporter here.
Yes.
And you swore to tell the truth, the whole truth, nothing but the truth, correct?
Yes.
And referring to page 89, lines 18 through 20. Let me know when you're ready. Are you ready?
Yes.
Did you give the following answer to the following question? Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love? And your answer was yes?
I did answer yes.
Oh, caught in a lie.
Ruh-roh.
And I'm caught choking to death on my own saliva.
Careful.
I have a saliva drinking disorder or whatever it was. Yeah. No, that never. Oh, you mean that paragraph where I said yes. All right. Yeah. Oops. Well, we did have one more thing. We definitely have wine to mark off on the card. We also have to mark off not intentional. So mark off wine and not intentional on your bingo card. And in just a little, excuse me, in just a little while, we will we'll review the entire bingo card here in a little while.
She does not, according, in your estimation, does not believe that she is special and unique and can only associate with high status people, correct?
No.
Does not require excessive admiration, correct?
Correct.
Does have a sense of entitlement,
Yes.
is not interpersonally exploitive,
Correct. He is not.
and when discussing whether or not she lacked empathy or was unwilling to recognize or identify with the feelings or needs of others, you indicated that that might be the case, but it's not intentional.
In other words, she's not aware if she's inconveniencing others.
So there was 3 of those traits, correct?
Yes.
Not 5, which would be required, correct? For a diagnosis of the personality disorder.
If that were the correct diagnosis, you would need 5.
All right.
That's a squirrely way to answer that.
During the
Yeah.
conversations with Ms. Boone, the defendant in this case, she explained to you that cheating to her means when Mr. Torres would look at pornography, correct?
Correct.
Not a real life woman, correct?
No, not that he was engaging in sexual intercourse with actual women.
Part of the records that you did not review were the text messages that were part of the phone extraction of her phone device, correct?
That's right.
You indicated in your conversation with Mr. Owens that some of the traits that are commonly seen in abusers would be control, jealousy, easily angered.
Those could be, yes.
What other traits just common for abusers?
Being a person who segregates their victim away from other sources of support, somebody that exhibits
Like their
coercive
family?
control, meaning that they would prevent the person from engaging in activities that would be independent, so restricting their ability to have independent, like life, job, money, things like that, that would be supportive of them being left, for instance. Other things would be using emotional expressions like rage to cause a physiological reaction in another person. So those could be additional descriptions.
What about making sure that they're never bored and are always occupied with things?
Specifically, the materials you reviewed. I just want to make sure we're on the same page. Paperwork from prior cases involving Mr. Torres and Ms. Boone.
Yes,
Medical records for Mr. Torres.
that's right.
The medical and Aspire records for Ms. Boone that we discussed.
Yes,
The crime scene photos from the incident in February.
that's right.
Pages 1 through 413 in discovery in this case.
Right.
A photograph of a suitcase and 2 videos involving the suitcase.
That's right.
And additional videos on that phone, correct?
Yes,
Such as baseball bat smashing the TV.
that's part of it. Yes.
And then did you review any other videos where there's conversations between Ms. Boone and Mr. Torres?
Yes,
One prior 911 call?
yes,
Now today you had indicated that you had reviewed the photographs from some prior incidents of violence, correct?
yes.
When is it that you did that? Is that recently?
No, there are photos included with the
The prior case packages?
case packages. Thank you. I'm not sure what to call it. So
That's fine.
All right.
All right. And did you review any body worn camera from those prior case packages?
no, I did not. I didn't have that.
Anything else that you reviewed that I've not covered?
Are you speaking of documents only?
Yes, yes. Materials other than your 9 visits with Ms. Boone.
All right. Just checking with the others I prepared for today. I don't know if, I guess that would be part of the discovery. The investigative report is within those 413 pages.
Did you interview anybody else personally besides Ms. Boone?
Yes.
Who else did you personally interview?
Melissa Sexton?
All right. Anybody else?
No,
You didn't interview Brian Boone, correct?
I did not.
You did not interview their child in common, correct?
No.
And you didn't review the phone text messages extracted from her device, correct?
No, I didn't.
Did you review any records from the jail?
No.
And, yes.
All right. Let's see. BB McD says, I think she was talking about how people may not realize that at the things they're experiencing or PTSD or similar. They might know they had trauma, but not how it affects the way they feel or think. Could be. But and Dyke Ida, thank you very much for the. Oh, there was a 15 Aussie. There was a 10. Thank you so much for the 15 Aussie bucks, BB McD. And Duncan, Idaho. I think it's hilarious that Boone told the psychologist that she's always puts everyone else's needs before her own, and she just bought it wholesale. Yeah. Seems to be the case. Thank you very much, Duncan, Idaho, and thank you very much, BB McD. Let's fast forward. Why? Because we can. And we're approaching today, so let's hurry. Let's hustle on through this. Got about 30 more minutes, then we'll be into today's testimony. Scrolling.
That doggy rolling, Rohan.
Well,
The objection is sustained in part and overruled in part.
How much longer
you
can we take
testified
our
earlier,
break?
in the normal course of practice of forensic psychology and psychiatry, you all do rely upon the diagnoses of other experts, correct?
You can inform my opinion, yes.
And you have not reviewed any electronic communications in the form of text regarding Ms. Boone's case, correct?
No, I did not.
Or recorded phone calls of any type, correct?
Well, 911.
Other than
No, other than.
Because
Now,
911's
let's talk about
funny.
the February 23rd, 2020. She told you that they didn't really have anything going on to do that particular day, correct?
Yes.
It was a Sunday, correct?
Yes.
Did some chores, and then as a reward, they could rest after doing those chores, correct?
Right.
She indicated to you that she and Mr. Torres did not begin drinking until about 4 p.m., correct?
I'll have to reference.
Page 36 of your deposition.
Let me help you.
Great.
Let me help you.
36.
Yes, ma'am.
I'll direct you to the exact page where I'm going to catch you out.
All right, I'm with you. Around 4 p.m.
And you reviewed the crime scene photos of this case, correct?
I did.
That included receipts for some purchases that were made at Publix on February 22nd and 23rd, correct?
That's right.
And one of those receipts was a purchase for a 1.5 liter bottle of Woodbridge Chardonnay at 12:17 p.m. on February 23rd, correct?
Yes.
Did you question her about the inconsistency of them having purchased a bottle of wine at 12:17 that afternoon and not start drinking until 4 p.m.?
No.
And did she tell you that they had any wine left over from the day before that they consumed that day?
At some point, I'm not sure if it was the day that I was going through this line by line with you in my deposition, but I am aware, yes, that there was an unfinished bottle of wine from some other date.
And then, as the receipt showed, there was 2 additional bottles of 1.5 liters of wine purchased at 12:17 p.m. and about 5:30 p.m. on the 23rd, correct?
Right.
And were you aware of approximately how much Ms. Boone, the defendant, weighed at the time of this offense, February 23rd, 2020?
Around 100 pounds.
And in the first 430 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Toro.
See, now everybody's accepting this 100-pound thing, but her arrest document said 140 pounds. So, and seeing the video of them in the public store, she looked to be significantly larger than him. But anyway, it's just the thing. It's like, why is nobody questioning that? Anyway, it doesn't really matter, but it does. It sort of does in the long run when you're talking about the metabolization of alcohol and whatnot.
I was going to say, I mean, if
February
she's
23rd,
heavier than what they're saying, then yeah.
Around 100 pounds.
And in the first 413 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Torres was 103 pounds at his death?
Yes.
Do you take into account this alcohol consumption when evaluating what Ms. Boone is telling you about the events of the day?
Yes.
Did she tell you whether or not she was intoxicated by the amount of alcohol she consumed that day?
Please silence your cell phone.
Well, there's another judge showing emotion. judge getting upset.
So she did not describe herself as intoxicated originally when we discussed this. So
So the answer is no. She did not describe herself as intoxicated.
intoxicated, right?
hypothetically, if she had told the jury that she was intoxicated at the time of the offense, would that affect your evaluation of her credibility in the history she provided you?
No, because that was also my opinion.
Did she indicate to you in describing the events of February 23rd, 2020, that there was any point in time she just simply did not remember?
Yes.
What points in time are those?
So she did not remember taking the videos of the suitcase, or the incident in the suitcase, until she was at the interrogation room, I guess, and then they were going through them with her. Then she recalled that.
I'm talking about specifically with you. Did she indicate that there were any portions of the night that, or day or night, that she did not remember?
I can't recall anything specifically right now.
Hypothetically, if she had indicated to the jury that she did not remember the 9 or 10 minutes immediately preceding the first video being taken, would that be inconsistent with what she told you then?
No.
Well, she didn't indicate to you that she forgot any part of the night, right?
Right. She just didn't say that. So
Would it affect your evaluation of what she told you about the events of February 23rd, 2020, if she hypothetically has testified that she did not remember 10 minutes for videos?
not really, no, because the event and the course of events that she narrated to me occurred over several hours. So when you interview somebody about circumstances of an offense, it's the usual for someone to not remember every single minute for hours at a time. I can't imagine that anybody's memory could hold that much unless they have like photographic memory or something.
I'm not asking about hours and hours of, an itemization of her day's events. We're talking about the 20 minutes of the offense. Does that affect the weight that you give her history she provided you? It's just yes or no.
No.
Now, what she indicated to you was the day had been going well. It was fun and games, correct?
Yes.
Conflict-free?
To her, she said it was a good day. So
Okay.
that's what she told me.
She said it was a good day.
Yes.
And there comes a point in time where the activities turn toward hide and seek, correct?
Yes.
And she goes up to the shower?
Right.
And when she comes down from the shower, that's when Mr. Torres is in this suitcase, correct?
Getting into it.
And she goes over to the suitcase and zips it, correct?
Yes.
And did she describe whether it was 100% zipped to you or just a certain percentage?
She said that it wasn't zipped all the way.
And still then, that was funny to the two of them at first, correct?
That's right.
And then there came a point in time where Mr. Torres was getting mad about being zipped in the suitcase.
She told me that he was getting mad. Yes.
And that, in turn, made her mad.
That's right.
What Mr. Torres was saying was, I can't breathe, correct?
That is what's recorded on the video.
Well, I'm asking you about what you recorded her saying.
Well, what made her mad was not that he was saying he couldn't breathe. It's what he was saying that was making her mad.
Well, what else was he saying?
At the time, she said that he said something that was making her mad. And so that's the extent of what we talked about at that moment.
So you didn't elaborate what something was that made her mad, correct?
Right. She said he said something that made her mad, and that started making her mad.
You didn't find it important to learn what specifically he said that made her mad, correct?
I don't agree that I didn't find it important.
Okay. And explain. Why would you ask that question?
Because as a person who is traumatized is describing their experience as a trained clinician, you will allow open-ended discussion of that experience. And so it's not an interrogation. You don't go asking confrontational questions at the time of their first narration.
Oh,
Well, you had 9 visits
bullshit.
with her. Did you follow up on your 9th visit?
I asked her different questions.
Someone needs to tell
Did you
my
ever ask
therapist
her
that.
Confrontational.
Did you ever ask her specifically in any of your 9 visits with her what it was that he said that made her mad?
No.
She never described him doing anything to make her mad, but it was words, correct?
Right.
And once she got mad, she decided that she was going to leave him in there for 2 minutes.
That's right.
Not 3, not 1, but 2, correct?
That's what she said.
That's what she said.
And the reason she was doing that was because she wanted him to understand how it feels to be choked and what she had experienced.
That's right.
Did you ask her why she didn't let him out of the suitcase after 2 minutes?
Yes, I did actually ask her that.
And what did she say?
Well, she thought that he could get out himself. That's one thing. She said that when she was able to unzip it, it was not some significant thing. She was able to unzip it easily. So she said it never occurred to her that he couldn't get out.
You may proceed.
And you reviewed the still photograph of the suitcase as well as the 2 videos.
Right.
And did you understand what the metadata or what the timestamps were for each of those items?
I'm sure when I reviewed it, I saw the timestamp. Yeah,
Would you agree that 20 minutes is 10 times as long as 2 minutes?
I would.
And if Mr. Torres had not been able to get himself out of the suitcase within 20 minutes, she didn't indicate that she let him out, correct?
She did not.
She described to you, Ms. Boone being the she, that she was helpful to the police.
Yes.
There.
Do you agree with that assessment that she was helpful to the police?
In the sense that she was having conversations with them without counsel, I would consider that helpful to the police.
Do you think lying to the police is helpful to the police's investigation?
No.
Objection,
Do you agree that she
speculation.
was not truthful with them?
Yes, I think.
Is the
that-
defense asleep? What are they
I would agree
doing?
with that.
And when she described getting Mr. Torres out of the suitcase, she described stretching his little legs.
Like, I've got an
Yes.
excuse. It's almost 1:30 in the morning.
And she stated to you there was no fight that day, correct?
That's right.
Just
Physical.
wanted him to be uncomfortable.
I need to clarify. Physical fight.
Right.
Yes.
Just wanted him to be uncomfortable,
Yes.
correct? And then there's a description of a bat and her using it to nudge, right?
Poke.
Poke.
Nudging with a
So-
baseball bat.
Do we agree that that means like poking out like this as opposed to swinging it like you're a baseball hitter?
I would agree with you.
And you reviewed the autopsy report, correct?
I believe so.
Did you get an opportunity to review the autopsy photos?
Yes.
Did you question her when she said that she only poked him with the bat?
No.
Not in any of your 9 visits?
Mark Stewart, Sarah
Did
zipped
I
it up.
question her about whether? Can you just repeat the question? I want to make sure I'm answering it correctly. Okay.
Oh,
Did
getting
you
flustered.
ever, in considering the autopsy report and the autopsy photographs that you reviewed,
Yes.
when she said that she nudged or poked with the baseball bat, did you ever question her about that, given the severity of his injuries?
So to answer correctly, I did question her
Was she-
about how she used the bat.
Okay.
And she reiterated that she poked and she gestured what she meant. So I did question her about that.
And did you have any questions about that history she relayed to you, given the other evidence in this case that you reviewed?
Just in contrast to the interrogation video. So that,
You don't, it didn't.
See, defense, she
contrast
can
to
within the
autopsy
scope of her
photographs
expertise.
or-
I believe that was outside of it.
I object.
Approach.
There you go.
About time.
Finally. Exactly. Finally working on it. Duncan Idaho, the $2. He menacingly said, Sarah, I can't breathe. Seed fan 85 of the Aussie $2. So what's the point of the glasses? She appears to be nearsighted.
You may proceed.
Did she indicate all this nudging or poking with the bat was done while he was inside the suitcase?
yes,
She never told you that there was any nudging or poking with the bat when he was outside the suitcase?
correct.
Nudge, nudge, wink,
She
wink.
indicated that she ended up flipping the suitcase over face down.
That's right.
Did she tell you about Mr. Torres calling his brother earlier that evening?
No,
Did she ever give you a history about a loud boom occurring inside of her townhouse that evening?
no,
And you never had the opportunity, obviously, to interview Mr. Torres about these things, correct?
of course not. No.
No other questions?
Any redirect examination? Yes, sir.
The state attorney talked to you about power and control, that an abusive partner will use power and control over the victim in a intimate partner violence situation.
Yes,
Threatening someone's dogs, is that an example of someone using control?
yes,
Taking car keys from the other party, is that an example of control?
If they're withholding, yes.
Taking a phone and withholding a phone,
Yes.
a debit card,
Yes.
destroying a home, TVs, putting holes in the wall,
Yes.
not helping pay the rent and other bills.
They're both shitty people. Can we agree
I
on
would
that?
say that that could be
Yes.
withholding, that could go under coercive control of another person.
What about violating a court order to have no contact with the person?
Yes.
That's all the question.
Thank you. Can this witness be released?
Please.
Sorry, the state is concerned.
Mr. Rhodes? All right, thank you, doctor. Collect all your stuff, ma'am. No worries.
Sorry.
No apologies necessary.
Well, I mean, Your Honor, she could apologise to the defence because I don't think they got their money's worth out of her.
Yeah, that was strange. That whole thing was strange. So they go to a break. Before we get to that, all right, we are just about ready to start today. So we're gonna play catch up here. Right now we got 709 people here, 557 likes. People, get out there and smash that like button. It's waiting for you, and it's free. It costs nothing. And the same for the subscription button. We need to get 44 more subscribers today. 44 of you. I'm sure there's 44 of you 700 that haven't hit that subscribe button yet. Do it. 44 subscribers will get us to 81,500. And Aussie Overlord needs all 700 of you to go on over there and subscribe to him. And you are very, very close to 32, right?
I was going to say, at this point in time, I will take 86. If 86 of you can duck across and just smack that subscribe button, 32,000. I was stuck at 31,600 for a year. And YouTube supposedly has just unshadow banned me. And I skyrocketed because I had a short that took off. But 86. And I'm over that 3,200 mark. 32,000 mark. That would be huge.
If he gets there, if he gets to 32,000, if I get to 81.5, I'll give the dogs more treats. Anyway, let's get going and just do it. We love you all to death. What are they doing here after the break?
Case where we got evidence of past domestic abuse. There was evidence of it. Started with the state.
Okay, we can skip through those arguments. That's not important. There's no more witnesses. They're just arguing lawyerly stuff. So let's bring up today. We are going to start with today. We are a little bit, I'm not sure how far behind we are. Let's push play here and check it out. We're just about 1 hour behind. All right, that's not bad. That's a lot less than I thought it would be. But before we get there, we do have a couple things to mention. One of them is Saddle Up Vicky Sue with a $5 says if the jury could see her home video, this case could be over in 5 minutes. I'm assuming it would. No, they've already showed it. They've showed it a couple times. They've showed the videos. That was during the prosecution's case. So yes, they have seen the videos, and they've heard the transcript being read numerous times as well. Seed Fan 85, facts don't matter, only her truth. I hate that. My truth, your truth, her truth, his truth. I hate that. There is the truth. That's a trigger word for me. The her truth, his truth stuff. Duncan Idaho has gifted 5 Legal Vices memberships. Make sure you give Duncan Idaho a super special thank you if you happen to be one of those 5 that got one of the Legal Vices gifted memberships from Duncan Idaho. All right. Think we're good to go here. We've got our closed captions on. And let's go. As soon as they're able to. Okay, here comes the witness. I guess they're getting ready to bring her to the stand. And then they go to a break after her, a very long break. Did they go to lunch after her? Damn, I think they go to lunch after her. Huh. Looks like we got about an hour of her, 45 minutes even.
Doctor, good morning. Could you state and spell your name for the record for us?
My name is Tony Antio, and I am Morn, W-E-R-N-E-R.
Thank
Dr.
you.
Werner.
You may be seated, ma'am.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And
I terrify the patients.
what your educational background is.
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University.
Okay, people, the defense has rested. She is a prosecution witness. They have started their rebuttal.
What?
Yeah, I guess that was the last witness.
You must have skipped over it.
No, that
Oh,
was,
damn. She's going to fry.
Huh. I guess that's what they were talking about after they left. Huh. All right.
Well, either that or was it the first thing they said this morning before the jury came in?
Could have been. Well, huh. All right.
To be honest, there was like 3 more witnesses than I was expecting. So,
Yeah, well, they got rid of most of their witnesses yesterday for the defense. So yeah, the defense has rested, people. Everything Sarah gets to say has been said. The last time we're going to hear from them is in closing argument. It's the prosecutor's rebuttal phase, and this is the witness that's going to rebut the last witness. Yeah, that was in the lawyer stuff we skipped. And I just figured that out. All right. Why is that not selecting? Huh. All right. There we go. There we go. Now it's doing. My browser is behaving a little bit squirrely. If I suddenly disappear, don't panic. I'll be back.
University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law. So anywhere where psychiatry intersects with legal issues.
This woman must be an amazing ventriloquist. She's barely moving her mouth.
And a psychologist.
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychologist or psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut, while I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have.
Approximately how many?
Thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are?
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual.
Again.
And this is the 5th edition text revision, which is the most current edition.
Again with the
Is battered
DSM-5.
spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and
That's me,
also
hyperarousal all the
avoidance
damn time.
of triggers or symptoms, things that would
Oh, wait, what?
trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and
There's a tension building up where you feel tension building
the
up.
incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase. And that's the third phase where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access to funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence and end up having this syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Put one on your butt.
And in this particular case, were you
Oh,
asked
sorry, I wasn't
to
muted.
do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there, wearing a dark suit and a pinkish top.
May the record reflect she's identified the defendant?
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes.
And where, who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, her work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right, is it all right if I refer to my notes just to make?
Just if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink. but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there and completed that, and then did some kind of artwork. She
Did they do
felt like
necromancy? Did
he
she put it on the table for her?
getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And sorry.
Oh my God, somebody get the woman some water.
And so she went downstairs and indicated that she had found him, and they were kind of laughing. And she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
If it refreshes your memory, just
Yes.
put them down and then tell us what you remember.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out, and her son's baseball bat was sitting there, and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on the human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to you's consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
It can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it's important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5, TR, or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about...
Yes.
Objection. I don't like his answer. It hurts my case.
It's devastating to my case.
Exactly. Yeah, help. Bad answer. It doesn't help us. Duncan Idaho, the $5. Call your daughter so you'll become more alienated from them since we're drinking. You should call your brother and explain what a piece of shit you are. That's exactly what she was doing. His daughters hated it when he called drunk, and when he was talking to his brother, she's in the background yelling, "He choked me, he choked me." It's exactly what happened. Duncan Idaho, the $2. Wow, that sounds like a really good day so far. Yeah, wake up, clean house, start drinking. Woo-hoo. Hail Vice Squad, says dude McFadden, I almost said. Boosh McFadden. Hail Vice Squad, Jeff and Ozzy. What is a ghost college breasts and titties? Happy Halloween. Thank you very much.
Bullshit. They call them boobies.
Saddle up Vicky Sue. Oh, we already did that one. You get a twofer. They saw the video. Thank you very much. That's it. We are all caught up. We can fast forward through this. We don't like her answer. We want to get it excluded. She looks like she takes shit from absolutely zero people on Earth. Oh, they got her some water. That's good.
Oh, thank God for that.
All right, this is a very long. Oh my God, this is
It relates to Sarah Boone. Do you have any?
Oh, this. All right. Looks like that might be the end of her direct. All right. We're continuing to go here. You've already had 2 treats, dog. Look at this. Nobody thinks this dog is starving to death. Absolutely no one. No.
Is she whinging?
Nobody's believing you, Straubs. Strawberry, nobody's believing you. Nobody thinks you need another treat.
Just our confidential matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure
All right.
that we were addressing
Did you
as
check whether he was
to
just sending them out, or was he sending them for lunch?
No, you just sent him out.
Okay.
additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had other depositions, as you're aware, yesterday, so I had to prepare for those and go through that.
To be
So
fair,
I
Princess,
have-
the wife and I do, but
I
it
have
generally
not
involves
had
our
time to
6-year-old.
Process on my notes.
What was that?
Oh, I'm the princess says, what grown-ass adults play hide and seek?
Ah.
To be fair, the wife and I do, but it generally involves our 6-year-old.
I need time to go through my notes, think about it, process it. But I had other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process on my notes.
Well, whose problem is
That's it
that?
on line 39. Well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could
It was.
discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnosis after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point, if my opinions change after having reviewed further. And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay,
that addresses specifically opinions
well, let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission. But she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail.
How have we not been watching this at
to being in a
1.25
correctional
speed?
setting right now. And
No
the
clue.
stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to depose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Werner says absolutely. And then, do you want me to continue reading or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, that's how she answered. She goes through a little bit of that. And then paraphrasing, she talks about the grandiose component of criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Werner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples. That was,
Excuse me for interrupting, but can we lasso this back in?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. And at this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or diagnosis of narcissism. The question pertains to PTSD.
all right, page 46. Line 1, question, okay. Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give any criteria with regards to that. She discussed having fear and anxiety of his family and feared that they would come into the jail or have someone else come to the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13, on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15, no. I would have to look back through my notes to see if she fully met the criteria. Question, line 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19, no. I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question, okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. That's specific to the post-traumatic stress disorder.
Okay.
So at the time of this deposition, when I asked her specifically,
So what's the legal objection? What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
What are
I
the
would be notified of any changes.
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection?
Get to the fucking point. Oh, silence.
I understand the backdrop.
Silence. When the judge asks you, okay, what is your legal grounds for this? What are your legal arguments? And you go radio silent, that's not a good thing.
Yep.
That's not a good thing.
I don't know if there's a legal ground other than.
Oh my God, he did it again.
As parties.
Oh, this is what he was doing this was in the pretrial stuff. Well, it's my feeling that this should come in, or I believe this really should come in. He's done it again and again. Now, I don't know how the judge is going to, well, I know what the judge is going to do, but I don't know how he's going to do it. Probably the one thing the judge hates more than when he says, what is your legal argument for this? And you go radio silent. The thing he probably hates more than that is the first thing out of your mouth is, well, I don't think there is any, but.
For any Aussies that are in the chat, we literally just had the Dennis Denudo. It's the vibe, Your Honor.
Oh dear.
Oh my God.
I wish you would have said vibe. That would have been funny.
I need that as a clip, honestly.
It's vibe. Because look, he is already not excited about this. He is already done with the defense lawyer. And then
look, the problem here is that the lawyer may be making a reasonable argument for something being wrong, but there's no legal basis for it. So yeah, dude, you got fucked over. You have to roll with the punches. You have no precedent to rely on here to postpone the rest of this testimony if you have no legal basis for it. Doesn't matter if you're being screwed over. That's your own friggin' fault.
Kind of is, isn't it? Well, let's see how Judge Kranig reacts.
Other than we had an agreement as attorneys, as parties, that I would be notified of change of opinion and I would be allowed to take a second deposition.
Professional courtesy is not a legal basis.
Because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no.
Mark off prosecutor frustration on your bingo card.
And I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor based on a very brief conversation yesterday and this morning was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was no.
Attorneys.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes, Judge, and that's his position, that post-traumatic stress disorder that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
That's irrelevant for the purposes of this argument.
Their discussions and him feeling like it didn't apply.
Okay. As an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not, it was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness.
Oh, swing for the fences, why don't you?
Change. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
May I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor? Yes. Am I misrepresenting?
And for those of you keeping score at home, something that I've been very, very impressed with this trial, the "what if any" phrase has been uttered exactly twice in this case, and both times by the judge.
In any of our conversations.
Well, that's just
All right.
patently not true.
And so if I
The
ask
prosecution
you,
said it during one of the.
if battered spouse syndrome or PTSD
Anyway.
has any relationship to the facts of the case as the defendant relayed them to you, what would be your
I didn't
answer?
hear it.
That it's not
didn't
related
hear it, so it doesn't
to
count. Fair
the
enough.
incident as she reported.
Or maybe it was one by the lawyer and one by the judge. I thought the judge did the first time. Could have been one of the lawyers. I can't remember.
Doesn't matter.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No,
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
no.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
What is the legal opinion?
The post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
Oof.
I would like to have known that, and that was going to be her opinion before today.
Dr. Harper is your witness.
Where is that a change in the
Judge, you
deposition?
have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it. and
Probably
find-
could have had discovery
Well, I asked-
violation on the bingo card.
I mean, this isn't the
Disappointing.
first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this, in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20. Let me know when you're there, Judge. Hang on.
Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1, yes, sir. Question. Then I go into fees. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion.
Very briefly, what's going on here is the defense is whining that they weren't aware that this witness was going to be testifying to what she's testifying to. And the judge is saying, so what? You've had the deposition for a long time now. What's your legal grounds for objecting to this? And he's trying to find one.
On the fly, which, you don't really want to have to be doing. I mean, look, to be fair, there is, in my opinion, grounds to his argument that she's testifying to a legal opinion as opposed to a medical opinion. And Seed Fan asked about how that was the case. For her to be on the stand saying that PTSD would not be a relevant defense for her is a legal argument. It's her opinion on whether or not she has PTSD would be the medical. I'm so tired. I forgot the word. Yeah, a medical opinion. Thank you. It's her saying whether or not she believes she has PTSD is a medical opinion. Whether or not it applies to the case is a legal opinion. It's a very small delineation and, frankly, not much of a win for the defense. But I'm trying to be generous to Owens at this point because he is floundering worse than Jack on the Titanic.
Well, I have a feeling the judge is going to just lop his head off here in a minute.
Oh, he's going to steamroll him like there's no tomorrow.
I believe it's a discovery violation because I should have been notified that there was going to be a change in opinions here today. And we
But
had
what's the
to know that I was
remedy?
gonna be
What are you
allowed
asking
to
for?
take the deposition and not be ambushed in the middle of the trial with a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the expert since a long time.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course.
Just let me do a Control F. Well, he's saying what they said she was going to testify to and what she's actually testifying to are different. And the judge is like, how? I don't know. I have to hear it again.
I mean, to be fair, the first time around, the judge did say that that was not the same answer that she gave. But are they substantially different? Is it enough to be an actual violation? Even if it is, how do you remedy it mid-trial?
Duncan Idaho says, speak your truth, Strawberry. And hey, this guy, Law, News, and Laughter with Aussie Overlord says, give the dog a treat, you slave driver. They're earning for you. He's had 2. And Snot Zombie, member for 7 months. He could get out of the suitcase because he had 2 fingers out. When she saw the 2 fingers, she feared for her life and hit him with a bat.
While Madam Court Reporter is able to provide that reading.
Must have been a hell of a lot to be so intimidating with just 2 fingers.
Yeah. Brummy, Nan of 2, new member. Thank you so much for being the newest member of the Clean and Sober crew. Brummy, Nan of 2, glad to have you here. I hope you continue to stick around for a while. I've seen you here recently, and it's always good. And Snot Zombie again with the $5 to continue from my comment. But then went upstairs to wait for him to come to bed. Wait for him to come to bed and have sex was what she said. And then she accidentally fell asleep. And here we are. Now, this brief moment to allow the reporter or the court clerk to find time to do this. We have to go way back. It takes like 30 minutes for them to come back.
I didn't say one way or the other.
Admits that. Mr. J has advised the court that's not what.
Hang on.
You've been present for all this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case and the defendant relate them to you, what would be your answer? Question, that it's not related to the incident that she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning.
He doesn't like the answer. I don't think that's the beginning of it.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning.
No, you asked for the proffer.
What was specifically asked was to the proffer, because the question before the court.
And the judge repeated that what you're asking for is for the proffer. You know the tall blonde-headed court clerk. She's like, oh, thank God I'm not on duty today.
Was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffer opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
Mark off lawyer confused on your bingo card. That gives me a double bingo, all in one fell swoop. Lawyer confused.
Tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them, based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
No, Dr. Leal, this guy makes Lionel Hutz look like a good attorney.
I can't believe it's a law firm.
I move for a bad court thingy. You mean a mistrial? Yeah.
Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, the answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24. I may. 25. Okay, and that's something you will let the lawyers know about if that changes. That's on page 47. Line 2. Yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering it,
proffer?
unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now,
Oh, she let you believe. Lawyer, ask follow-up questions. Yeah, she let me believe this. Well, that's your fault for believing it. Oh my God.
Well, hang on. No, because it wasn't when she was on the stand. It was in the deposition. She said that she hadn't formed an opinion yet, and he said, "Well, you will let us know if you're going to form one," and she didn't. I mean, he could have just as easily asked.
She's letting him know now. She's got a different opinion, which is what he's complaining about.
Yeah.
Let's see.
Nothing's going to come out of this, but I can understand why he's pissy.
the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back when it was first going on, when the question was asked, and I believe she rendered an opinion. And I, again, like that, we read back what the initial question was, what the response was, because it did. I know I objected. I can't even remember it now, but I know I objected because I knew it was inconsistent.
You asked to approach, and then you explained that the question was, it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection.
Because he was doing it on the fly.
If you want Madam Court Order to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer if BSS or PTSD has any, can you reread that?
Let's just reread the entire proffer, just so that it's clear, soup to nuts, alpha to the omega, what the proffer was. Madam Court Order, if you can be so kind. Yes, ma'am.
That's why you're the judge and I'm the law talking guy, the lawyer. Right.
All right, let's fast forward to.
Question. You've been present for all this hearing. Yes, doctor. Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, does that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if you could go back to the initial.
It is a concern, Grifter, but yeah, they're allowed to sit in on the testimony.
Well, Slidey Pie over on Rumble says it'd be nice to be able to hear. Well, it would, but your court clerks and court reporters are normally not mic'd up because they normally don't speak.
Pay no attention to me. Oh, I was waiting on you. Please, go ahead. Sorry. Pay no attention to me. Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her in the jail.
Can you read that for me one more time, please?
Yes.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Maybe we have the previous question as well.
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end, some general, if you have any new opinions or anything new that differs from what you said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question to get the answer that I intended to get was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer is going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's not the scope.
Any other argument?
The totality, if you read that deposition and all the
I specifically asked you, Mr. Owens, to point out for me what, excuse me.
Oh, whoa, mark off. Now what did I do there? What have I done?
Start.
Well, that's not good, is it? Hell. All that just because I was excited because we finally got to mark off defense interrupts or ignores judge on our bingo card. Should be somewhere around here.
They didn't ask about the interplay of the facts.
Perfect. Look at that.
With, the relevance of this.
So now do it one more time. Mark off. Defense interrupts or ignores judge on your bingo card.
Syndrome. That's them, not the state.
Any other argument?
Does defense claiming
I specifically.
does the defense claiming a evidentiary violation count as them attacking someone's credibility?
Probably not. Well, maybe the defense lawyer's credibility. We'll give it to you. Defense attacks credibility. I didn't specify witness credibility. He's attacking the lawyer's credibility.
Exactly. Right. Lawyer.
How has nobody dropped an F-bomb yet? Huh.
I asked you, Mr. Owens, to point out for me what, excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find the solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed,
other than what you've already identified.
The ones that I expressed, and that just the understanding that we had that she, in the pages that I have talked about previously here today, the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J? Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
No, other than I understood she did give an opinion about post-traumatic stress and that additional serious question.
Okay.
All right, and a Richardson hearing is sort of like a Brady violation hearing. What was got the questions he's going to examine are: was there actually a violation? If there was it an intentional violation? And what was the impact? What's the scope of the impact on the testimony on the trial? All right, well.
This will be a good way to waste 20 minutes.
Yeah, and now it makes sense. He was writing this shit out while they were arguing about it. Now him crumpling up the paper and throwing it in the garbage makes a little more sense.
He knew where it was going, and he knew he'd have to hold the trial, the hearing. So.
And Heather Sparrow is gifted 5 Legal Vices memberships. Thank you very much, Heather Sparrow. If you got one of those, hope you gave Heather Sparrow a super special thanks. That would be Lynn Musta, Dopamine Octopus. Where do you people come up with these names? Snot Zombie, Dopamine Octopus. Let's see who else here. Samantha Phillips, Andy's mom. That's understandable. And Mally MC, Mally Mc, and John B. Beatybot. Okay. You guys got gifted memberships from Heather Sparrow. Make sure you give Heather Sparrow a super special thanks. Looks like we got a Brady hearing coming up, or a Richardson hearing, as they call it there in Florida. Right, let's go.
All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Warner's deposition, that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial, although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
Don't swing for the fences. He's not going to give you it.
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress.
Yes.
It's going to come out through my cross from the deposition about what she said, and it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
I'm going to bitch slap
Are you
him.
on board with the strategy not to seek to strike that opinion?
Yeah,
All that, and he's not even asking for it to be stricken. I'm going to fucking bitch slap him.
We literally just wasted 47 minutes of our life for no fucking reason. He's like, oh, never mind. I'll just ask about it on cross-examination.
Fuck you, Owens.
Well, we're going into next week. I thought we might be done by tomorrow. Monday, I'm guessing verdict, perhaps. Holy shit snacks. We just wasted 47 minutes.
That is like the biggest dick move ever. He fumfed about. He actually got it over the line, and he's not even going to go for the curative instruction.
Wow.
Was he just trying to delay it as long as possible so that the jury, there was an interruption of the testimony, or was this?
It could have been. Oh my lord!
It's the only thing that I can think of. And no, my F-bombs don't count for bingo.
Yeah, they do.
Sorry. Oh, do they?
Did you drop one?
Like 3.
No, I've become immune to them at this point in my life. All right. Well, shit.
I hate this guy. I hate this guy.
Does that count as lawyer overacting? I was thinking he was a little overacting a little bit there. So, yeah, why not? Let's just go full on bingo tonight, people. Island with the $2. Prosecution witness disagrees with defense. Shocker. And Duncan, Idaho. If you give Owens an opportunity to speak, even if you say don't rehash what you've already said, he's gonna do it exactly that every time. Well, and then he's just gonna say, oh, never mind. After an hour. All right. Well, that was fun. Exactly. Sheena just literally speaks.
Thank you, Seed fan.
Get back to it, I suppose.
Oh.
Shit. Yeah, I'll give a bingo recap here in just a little bit, just a few minutes.
Yes. Thank you.
Oh, dear.
With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes.
Oh my God, they're doing an in-court deposition.
With regard to the proffered opinions. And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren.
How does that cure the prejudice? Yes, they're going to get the answers, but no, he's not going to have any prep
At some
time.
point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Is the jury back?
No, the court is overseeing an in-court deposition over her now about the changed opinions. The judge said, because you don't want it stricken, because you're going to rely on it in cross, I will oversee a deposition here and now because I believe that will cure the prejudice to you in this time. And my argument is, fuck that, because even if he gets the correct, even if he gets the answers out of her now, he's got no prep time. Unless immediately after this deposition they go to lunch, and then he's got, what, 90 minutes?
Yeah, they're going to go to lunch, but Sarah excels at everything she does, so she can help. Well, 3 things real quick here. Number 1, there's a reason I'm wearing the hat I'm wearing today. I'm the shit show supervisor today. There's a reason I'm wearing this hat today. 2, item number 2. Let's bring everybody back here. Where'd we go? Item number 2.
I know my bad mood hat.
We got to the second tier. We just recently reached the second tier of achievements, which is my punishment for keeping the dogs behind a paywall. A shot of very bad whiskey, which happens to be Fireball, and looks like we got about 2 left in there. So one more second tier day, and that should be that'll be enough. Got like 1 more left in there. So cheers and thank you for getting us to the second level. Oh God. Ugh, I can't wait till this is done. Ugh. Cinnamon flavored syrup. Ugh. All right, that's number 2. Number 3. Oh God. Number 3, the bingo card. Is an on-demand depot normal? Well, no. But you gotta go with it. All right, the bingo card, for those of you playing the bingo, it would actually be easier to tell you what we don't have marked off. There's only 1, 2, 3, 4, 5, 6 that we don't have marked off. Lawyer confused. These are the ones that should be marked off. Lawyer confused. Baseball bat. Dog cam. Wine. Judge shows emotion. Defense attacks credibility. Hide and seek. What, if any? Prosecutor frustration. Lawyer calls for sidebar. Vice's boomers something. Suitcase. Judge calls for sidebar. F-bomb, thank you. Sarah is the victim. Defense interrupts or ignores judge. Not intentional. And lawyer overacting. I got like 1, 2, 3 bingos now. Noticeably absent. No dog snoring today, weirdly. No viral moment yet. Shh. Nobody said shh yet. Court technical difficulties. We have to mark off Celine Gomez as well. Mark off Celine Gomez. That's the name we've given to the seal of the great state of Florida. We've seen Celine Gomez lots of times. So we have 5 that shouldn't be marked. Court technical difficulties. Shh. Viral moment, dog snores, and Sarah shows emotion. I don't think we're ever going to check off Sarah shows emotion. Nikki Lynn, it is impossible for you to only have 1 bingo at this point.
I got 3.
It's impossible. I've got 3 as well. I'll have 6 if Sarah shows some emotion. But, all right, let's hear this deposition. This should be fun.
This ain't gonna cure shit.
What?
This ain't gonna cure shit.
Nope. It's just gonna make the jury pissed for having to wait like hours.
Tonight, have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct, that my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
But that's not what you said
Okay.
before.
And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct, that was my opinion, correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that.
It's in
but
the
you're saying you
deposition.
formed that opinion prior to the deposition, correct?
Yes, the state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition.
No, sir, after the evaluation.
Okay.
On the way out of the jail.
All right. And I asked you, were there any other opinions that you may express at trial after you had discussed that with a state attorney prior to the deposition? Is that correct?
Yes,
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
This
But you
woman's
know
been in a
that
few
this was a
depositions.
central issue in the
Yeah.
case. Did you not?
I-
Your opinion
Yes.
is relating to a central issue in this case.
Correct?
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any question.
See, Island is correct. He said, do you have any opinions about anything else? He said, nothing that you've asked about. None that you've asked about. If you ask me about other things, I will give you my opinion. That's what she said at the end of the deposition.
That's a squirrely answer, though, and he should have known better.
He should have known better. Yeah, she answered the question, so.
Like, this is what I'm really annoyed about. I hate her answer. I hate how she's responding to this, but he's the one that done fucked up.
Yep. She's a squirrely witness who has been in more than one deposition.
Mm.
She's good at this, and unfortunately, she's better at giving answers than he is at asking questions.
That were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
That did not help you, Owens. That hurt you.
Anything else?
Mm-hmm.
Just making sure you want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to
Inquire about
You
what? This is. Mr. Owens, this is your opportunity to inquire. About what? What the fuck do you think, Mr. Owens? I can't with this anymore, Hayden.
I know. I'm sitting here thinking, honestly, if I didn't know better because I know he's already cleared the bar for it, but I would
35
swear to
years
God
criminal
that between the
defense.
three of them, they're trying to go for an ineffective counsel. But they've already cleared the bar. That's
30.
the thing.
35 years he's been doing this.
35 years of pushing paper around, apparently. Holy fuck.
About what, Your Honor?
Stupidest thing that could have come. He has no filter. That is literally the stupidest thing that could have come out of his mouth.
He just literally said, "This is your opportunity to inquire." And he says, "About what?" Oh, that's great. I don't know if it's just because, God, it's 3 a.m. for you. I don't know. It's just because it's 1 a.m. and I'm punchy, but that was funny. All right.
Yeah, but it was pathetic funny.
Yeah. All right. Let's go here.
I'm just making sure he's.
It's like watching a kid stick a fork in a light
This is your
socket.
opportunity.
Yeah.
I'm just making sure he want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner,
Why
will you
didn't
give
you
me
raise this beforehand?
I mean, that's standard operating procedure in these type cases. And now I'm
can
taking
throw
a
something.
deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not.
It doesn't matter. She
That's
wasn't subject to recall, was she?
It just puts
Good
me in a
question.
very difficult situation. But if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom
Yes, sir.
and we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing?
Oh,
to
fuck
answer
off.
any other opinions that you intend to
It's
express
deposition.
here today as it relates to Sarah Boone, who is on trial for murder in the second degree?
Judge, I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have. 99 out of 100 attorneys will come in here and say, that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert always.
Do it as a yes, no. Do you have any other opinions that could affect this case
That's what she's doing now.
that you intend to proffer in court?
It's unfair and vague to ask somebody, tell me every opinion you have.
Judge.
Yes, sir.
We're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here? In the middle of a trial?
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
All right, can I continue with my deposition?
Yes, sir.
Oh, Jesus.
Dr. Warner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I'm leaning towards a adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with George Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
In your opinion, does she suffer from any form of psychosis?
No.
Real quick here, they've just gone to lunch break. We've got one more hour to go. We're about 1 hour behind, so about 45 minutes for us. And Hayden, how are you doing?
I was going to say it's 3 a.m. I don't know if I'll last another 45 minutes, but I'll try.
Can you last 10 or 15? I actually do have to make a call to England right now. Getting on 5 p.m. there. I was expecting a call. I need an answer before I wake up in the morning and go to the office. So I got to call someone before they leave the office. Can you run this shit show?
I will hold the 10 to 15 minutes, and I promise I won't drop any C-bombs and get the channel demonetized.
Cool. I'll be watching.
Always watching, Wazowski.
Here we go.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's
So you haven't
possible.
formed an opinion
Is
yet?
that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that. Yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
Well, shit.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 of 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can.
Before we bring the jury back in, may I approach Mr. Cacciatore with the unrelated matter?
Does it need to be on the record or?
It does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying against us here in court this morning.
They're still under defense subpoena. We have not,
I asked Mr. Henderson if you guys were calling Capsule again, and he said no.
and we're not. in our defense, our direct defense, is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek rebuttal, and possibly through these witnesses? They're under subpoena, and I'm sorry, Ms. Henderson's not here. I just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in rebuttal. But
It doesn't answer my question. What's the legal basis of a sir rebuttal?
judicial discretion as to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case.
Now what just happened?
So the deposition came to an end. He asked a few other questions. He made the ruling that they're not going to strike the testimony because that would be draconian in his view.
Yeah.
And then it turned out two of the detectives are sitting in the courtroom, and the other lawyer had an issue with that because she was potentially still going to wind up. One of the detectives might still wind up on the stand. So the judge has just ordered them out of the courtroom.
All right.
And any questions or testimony that you intend to give, may give, or have give, and to comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much. Anything else, Mr. Owens, we need to address?
No.
Anything else, State?
No.
All right, let's bring back in our jury.
God dang. That was a stellar waste of over an hour. Oh my God. That was a stellar waste of about 2 hours. Well, yeah. All right, we'll give him an hour and a half for this shit show there. Let's fast forward to the judges, the jury.
You instruction again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
Jesus Christ! How long has he's been sitting on that for that entire time?
He just asked if he wanted that last comment struck, and he said no. I'll ask about it on. Oh my Lord.
No, because the state said that he wanted to have the last comment struck.
Oh, okay.
But still, he still just sat on that for like the last hour. I'm mad at all of them now.
What are you guys malfunctioning about?
Is the ghost back?
It could be.
Opinion about whether
Let
Ms.
me
Boone
go
was
figure out
suffering
what the
from
hell's going
PTSD or
on.
PSS. Irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or PSS have any relation?
Overruled.
No.
And what
Yeah,
particular
there was no
part of
answer.
her,
Well, I mean, it might have been
statements about
answer,
the
but that was over an hour ago.
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing when he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or there was an imminent risk of harm that she needed to protect herself.
Yes.
Now what? Like, look at that face. She's getting huffy too. You can probably zoom out just a little bit, Mr. Cameraman. Yeah, this is getting a little bit ridiculous, honestly. I mean, it was always going to be contentious because she's going to have to. They're going to try and have her dance around various things, and it's not going to go well. Yeah, she's a smart woman, and whose witnesses is prosecution. We're on oh crap, what's it called? Rebuttal. So she is the medical psych doctor for the state, and she tore apart the defensive psychologist's assertions, but I don't like her. She comes across as very smarmy, very shady to me, but she's doing her job well, honestly. Cameron's scoping out his lunch. Enough. I don't have the lurch sounds.
The house is clean. I don't know what that was all about.
Okay.
House went looking for snacks, but there's nothing that doesn't have 8 million calories in it. So I'm back. Apparently, we're just sitting around listening to them sidebar, huh?
Yeah. Got through a whole
Members of the
question.
jury, I have something I've got to discuss with counsel.
Oh my God.
Oh,
Same
for
instruction.
fuck.
Please don't conduct any independent investigation or research on the person, places, thing, or charge involved.
One
and don't have any
question. We got
conversations
through
among yourself or
one
anyone else with regard to that,
question.
and we'll bring it back in as promptly as possible. Thank you.
Oh no, the judge is going to be irate.
Question. Just go from read it from the question, answer, question, objection. Let's just have we can buttress it.
And he's trying to be nice to the court reporter, which is nice. Oops, sorry.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether this Boone is suffering from PTSD or BSS, irrespective of that, based on your evaluation of this Boone, what she relayed to you about the facts of this case, does PTSD or BSS have any relation? Mr. Owens' objection, asked and answer. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time. They were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having a good time. All of that isn't consistent with her having a feeling that she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat. Is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm going to make a decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
It's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion on the applicability of a particular set of evidence that the testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not out there saying Ms. Boone was unjustified in doing what she did. She's not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time, despite his mental illness, because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony.
Any other argument, Mr. Owens?
That's totally wrong. He claims, the prosecutor claims Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976 7 2nd 660 at pinpoint 661. In that case, a psychologist testifies, and in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion. See section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court, I'm just going to ask you to read the question and answer, and I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He's going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
Oh, my
I
Lord.
object.
Basis.
It was asked and answered.
Overruled. There was a pending objection. Allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to need at least an hour for mine.
We're going to begin your cross-examination after we're done with after the state advises the jury in open court. There are no more questions. Let's go ahead and bring back in our panel.
Mama Laurie, new member. Thank you so much for being the newest member. The Clean and Sober crew. Boosh. Why didn't you answer the question I didn't ask, Owens? Duncan, Idaho. Sarah, right now, I should have taken that plea deal. Dara the Wholesome. I'd argue saying uppity to the granny is viral, Lamau. And CMEF Fashionable, good to see you here. I think I had more fun at my graduation than watching this.
Ouch.
And a Dare K member for 5 months. I hope the jury got snacks. Yeah. Juries get snacks and pay. Not much pay, but they get pay. You should get double for this.
Get the pay per day and plus per mile of walking.
So we got about 25 minutes left of this.
That's to recognize our jury.
I think.
Question by Mr. J. All right. Irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or ESS,
About 20 minutes.
And that based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and ESS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time. They were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
Dr. Warner, good morning. What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had
That's the 2-hour interrogation with Detective Lowen and Detective Copson.
It was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
Do you agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
You said you considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Yes.
Oh, now they're just having objection wars at this point. If he sends the jury out, I'm going to crawl through my computer monitor, go back in time, and kick somebody's ass.
Text messages that you provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
No.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours.
Oh my God.
On October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes.
She's like, motherfucker. We feel your pain, doctor. You're getting a cup. You're getting a chunk of cash sitting there. So chill. You're getting paid way the fuck more than we are. So keep going. Oh my God. Well, we're going to be going to lunch sooner than we expected. Oh, did that count as emotion? Her lips moved. Oh my God, this is going to be over pretty quick. Are they going to go to lunch before anybody says anything else?
Fingers crossed.
I think they are. Oh my God, I think they are. Oh, nope. Exactly, Strawberry. Why is this buffering here? Oh, there we go. Phew. How much
Ma'am,
longer?
is it fair to say, in your evaluation of Sarah Boone on October the 2nd of 2024, that you felt like
10
the
minutes.
text messages that you received from the state attorney
Overruled.
are not relevant to your evaluation of Sarah Boone?
I wasn't sure at the time who actually I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the secretary appeared by Zoom.
Yes,
And we discussed that these were the phone records from Sarah Boone's phone.
yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
I have it. If you just refer me to the page.
Just a moment.
I do.
Page 14.
Lawyer getting pissy.
My question is at line 3. Your answer begins at line 5.
He's joining the rest of us.
Correct.
And you agree that any,
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5, approach.
Owens, you're not making this easy for anybody.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone? Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14. My question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's talk. First, you said no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
relationship. It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time, you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship.
Correct.
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot for overdrafting her account.
Correct.
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Oh, my sweet baby dumpster Jesus. Enough of this. Owens is getting owned by this woman. He's getting manhandled by her. He's getting bullied. He's sounding whiny. Little Wingosaurus Rex. Jeff and I did the same noise out loud. She is done. She's like, you made me sit here on the stand and watch you people talk for 45 goddamn minutes. Oh my. We are moments away from going to lunch here, people. I think we're going to lunch now. This is it. This is the wrap up, people.
Similar instruction that I've given you throughout the last couple of days.
There you go.
Give me a moment to pull it back.
Let's see if they said anything or if they just went to lunch.
All right, members of the jury, It is 11:55. At this point in time, we're going to go ahead and take our lunch break. I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up.
The jury's like, we haven't done shit today. You've wasted our entire day, you
Jurors,
friggin'
you must not
lawyers.
conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point in time. Thank you so much for your service.
And this is where we're going to shut down our stream for the day. We have reached the end. And don't go anywhere, people. We still got a few things to discuss. Don't 10 of you just left. Stop. Don't leave. Just listen. Just nobody cares. All right. What's going to be happening is tomorrow we will do the afternoon of day 5 and the beginning of day 6. We'll do afternoon of day 5 and up to the lunch break on day 6. But then Friday evening U.S. time, beginning at 9 p.m. Eastern. That'll be 2 p.m., same time as we normally do, but it'll be in the p.m., not the a.m. We will be having the October Griftaween-thon.
Oh my God.
It'll be Griftaween. It'll be Griftaween. We're going to have the Fuck It Friday Griftaween, where I'm just going to grift from you. We've got all kinds of stuff. We have punishments. Every $100 that comes in, however it comes in, we spin the fickle wheel of fate and fortune for Fuck It Friday, and we do whatever it says. Whether it's eat something delicious, whether it's have some steamed silkworm larvae, take some shots of bad whiskey, and there's a few other new additions. We've added something that just arrived that I'm waiting to see what happens. Oreo flavored Coke Zero. We'll have to see what that's all about. That's one of the wheel items. There's a whole bunch of stuff. $100 Temu shopping spree. We'll be doing the unboxing from last month's Temu shopping spree. It's just a fun time. We're gonna have a huge panel of guests. And for those of you that are in the LawTube true crime genre, you may recognize many of these people that are going to be on the panel. Here is the guest list so far. These are the people that have said they will show up. Danny on Direct, Nick Starro, Radix Verum. Haven't seen Christina for a long time. Ozzy Overlaw says he's going to be there. Paralegal Liz, Potentially Criminal, Moxie Dame Jess will be here. Our very own Flux will be here. AV to the 7th Power is going to be showing up. Megan Fox, Runkle of the Bailey, Kaiser Pineapple, Danielle, the legendary Max Mura, Lady Law 579, and Lauren De Laguna, who we have not seen in ages as well. Those are the people that have confirmed their attendance, and the list will continue to grow as more people show interest. We're going to go from 9 p.m. Eastern until until I decide not to go anymore. But I do have a hard out 8 hours. I hope we don't go 8 hours, but if we do go 8 hours, I'll shut it down the 8 hour mark because I've got a birthday party to go to. It's like it's Russian birthday season. It's like there was nothing to do in Russia in January other than stay home and make babies. It's almost like you can't go outside in the Russian winter. But yeah, it's like January, 9 months later, everybody's born. What do you know? Got to stay warm somehow. But yeah, so that's what's going to be happening. Do not miss it. We're going to have a great time. And that's it. All right, everybody, I'm going to send you off into the wild now. Take care. Hayden, you're a trooper for lasting till 3:30 a.m. Make sure you show some love. Show some hot buttered koala love to Aussie
Ugh.
Overlord.
Keep the chlamydia out of it. Come on.
for doing this. Make sure you get on over and subscribe to him over there, Aussie Overlord.
It's Friday tomorrow, people. We got our weekly WTF law roundup. I butchered the hell out of that. My what the fuck news stories for the week, where we just go through the random news that just makes no sense and usually involves a smoking gun. So
awesome. Be there or be square. And that's kind of it, folks. We got a few more subscribers. We need 42 more subscribers to get me to my goal. Yay. So hit the like button. We got 697 likes today. Thank you very, very much. We got to the second tier of achievements. Guys, mods, thank you so much for the long haul today. The Sarah Boone trial is coming to a close. Thank you, chat, for being here, for the super chats, the gifted memberships, the purchase memberships, and for unlocking the emotional support potato pig dog cam for the 41st day in a row. We'll see if we can make it 42 tomorrow. Chat, thanks for being here. You guys are awesome. The best chat on the entire internet.
Jeff, Megan's telling you to redirect.
Fuck this shit, I'm out. Fuck this shit, I'm out. No thanks.
Megan is asking me to redirect to her. So anybody wants to go watch Megan play video games and American Truck Simulator and drive her truck about the Western United States, I guess we'll send you over there. let me handle the redirect here. Everybody's yelling at me. No, Jules, no. Jules was not in court today. All right, let me go. Hang on. YouTube studio live content live. Hey, thank you for whoever just made the last membership subscription, not the membership, just the regular subscription. Whilst I was talking about it, somebody did live right now. Go to customization, redirect, search. Recovery addict trial. Megan is upcoming. All right. Fire up the grill, Megan. Here we go. Bye, everybody. We'll see you later. Go on over to Megan Fox. You might see a recognizable face over there. Who knows? Let's see. Out. We'll see y'all tomorrow. Same bat time, same bat channel, 8 a.m. Eastern. Until then, enjoy your legal vices. Don't stick anybody in a suitcase. Bye.